submitted in this matter. So
You want to withdraw?
Lordship with liberty to
You always have to leave. On the prayer of MS
aforesaid.
proceeding, and council. The matter is dismissed on as of the
With liberty to
liberty is always there.
oblige also.
You can always go.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 41, Lordship. Lordship, a report was called for, and as per instruction, the report is not received, Lordship. The date may be fixed, Lordship. We have not received the report, Lordship. Whether any case is pending against the petitioner, Lordship, that report was called.
So maybe the council submits that no report regarding filing of an complaint or a file is sought from the concerned police station or same is confirmed by this. Same is confirmed by this. If it is shown that with the federal list 16.6 on 16.
Nuclear of life, Lordship.
Maybe it's Your Lordship. I beg to mention item number 24.
24.
Final adjournment matter for today.
On the prayer of Mr. So
List the matter on
adjourned for it.
and list the matter on 18 or 19 of this month.
18. Let the matter listed on 18.
Bless Your Lordship.
May please mention item number 36. CD is not available.
36.
Yes, Lordship.
It is not available.
Did he not receive it?
I'm on interim.
CD is awaited with the matter be listed when.
Interim
Interim
production.
23rd, 23rd.
Lordship, interim production may be continued. Interim production may be continued.
Interim order so far started.
May I please, Your Lordship. Lordship, I beg to mention item number 38, Your Lordship. Lordship, out of same CD, Honorable Court number 14 has fixed the matter on 15th, Your Lordship. Maybe take along with that, Your Lordship.
We have not received a CD. CD is in another court. These are in fact. It can be fixed on along with that.
What is the other number?
AB number 95026.
Council
26.
Another AB application that is number
AB number 950
150 or
26
26 is fixed on
15th, Your Lordship.
15th. 15th and pays for taking of the instant matter with the other matter. Let both the matters will be
Interim order may be continued till
interim orders of first and second.
must.
May I please, Your Lordship? This is 483 application, Lordship. Petitioner is behind the bar from last 35 days, Lordship. FIR is page number 11. Type copy, Lordship. We are one of the accused person used my bank account to receive cheated money, Lordship. Here, may I read, Lordship? I respectfully submit that since 2006, I have been associated with a person named Jivan Tanti. On 1st September, Jivan Tanti informed me over phone that he had obtained a post of executive member in Oil India Limited and that Dr. Rajiv Kumar Mohato had become executive chairman. He stated that Oil India Limited currently requires 15 Scorpio vehicles and that each vehicle would earn around 1,30,000 per month. He further said that Oil India Limited had issued a tender and that work order should be given after depositing the tender payment through online transfer. Believing his statement, I agreed to provide 10 Scorpio vehicles. Later, he informed me that the monthly amount for each Scorpio vehicle had been increased, and following communication through WhatsApp, he instructed me to transfer money online. Lordship, this Rajiv Mohato used my account.
Yeah, we'll have to see the.
Lordship, Lordship.
Third MS services are direct concept. Use of as well. State. Like this is an application. Application and the section for PNSS. Link for a link for a by the use of and people should under section 61 comma 316 bracket 2 comma 316 comma 312 bracket 2 319 bracket 2 all for the city the mathematics one 19.6
Highly opposed.
May please, your lordship, this is a regular bail application and matter is connected with the dispute case. So, lordship, at this stage, case diary may be called.
Right, kill lordship. 18.6.
hard business is an expedition on the 4050 of kilometers. Play for criteria, play the connection base case number 836 PNS. Call for the city and then the deck is the victim.
Blessed.
May I please, lordship, the perusal of the case diary would be necessary in this case, my lord. Though the item has been recovered, but the perusal of the case diary would be necessary. Lordship, may kindly fix a short date, my lord, already 31 days behind the bar. Allegation under criminal breach of trust and, my lord, administration of intoxication. Petitioner was the driver of the vehicle.
Mr. Swing.
He does, lord.
He does the right counsel. Like is a transfer to state. Is an application under section 40 of BNSS praying for bail. Like use application. Election Potasila by PS case number 49/6 under section 123 for 1305 bracket C of PNS 2023. Call for the case diary. The matter fixed on
17.6.
17.
Obliged, lord.
May I please, your lordship. 483 application, my lord. Your lordship will find that all sections are well, Raxar 196, where maximum punishment is 3 years, my lord. There is allegations that I took money from being a journalist, my lord. But for that statutory requirement, 35 has not been complied with. No notice after 35 has been issued to me. 35.3.
Okay, we'll call for the city.
My lord, I take your lordship the FIR. What is the one? The BJP party of the Lamning unit has lodged this FIR. If this person, who is a journalist, my lord, that he is publishing the news against the local MLA and his family. So, my lord, that is the purpose. If is anything wrong, he could have a letter to the in the correction of this news item, my lord. That is the mandatory provision of the journalism.
We'll see what is there in the city. We'll give us.
35 has not been completed on this very face of this matter. He is entitled
We'll see
bail.
what is there in the city, Mr. Biswas. We'll see what is there in the city, whether those things were complied or not. We'll see. Let us see that.
There is no reflection in this arrest memo, my lord.
What Mr. SC Biswas net function paying for the fees of taken also not disability also and AP products. The application was supported to PMS system 023 paying for bail to the accused applicant in connection with Lamdi PS case number 80/2026 under section 296 bracket A small a stop 226 bracket 2 stop 308 bracket 5 stop 196 bracket 1 of PNS. All for the city.
18.6.
My lord, I play short date, but it is in from Lamning, my lord.
Today is
The
what.
arrest is whole arrest is illegal, my lord.
We'll see that. We'll see if it is illegally being.
Little earlier, my lord. Little earlier.
17 you can do it.
One day, it's later to 16th on my lord.
17 is fine. I mean, otherwise it will not important for proper. Today is 8.
Yes.
Lordship, he is behind the bar for 39 days. He was arrested in a my lord certificate matter. He was absent for some days, my lord. He went to Kerala for his livelihood. Now he has come back, my lord. Police arrested him 39 days behind the bars, my lord. Case is, my lord, evidence test. Last order, my lord, that is page 29.
Records may be called for case of 376.
Once he was arrested, then allowed to go on bail. Now he remained absent for some days, my lord. Again arrested.
You will see the TCR because see, I mean, but this cannot be a ground. I went to Kerala, I went to Madras, I went.
I understood, my lord.
When a 376 case is going on, trial is on, evidence is, you can't leave just like that and like and do not cooperate with the trial. Can't be like this. Heard Mr. BB Gopal, the learned counsel. This is an application under section 483 of BNSS 3. Praying for grant of bail to the accused applicant in connection with Boko PS case number 2438/2023 under sections 448/376/511/354/506 of Indian Penal Code. I mean, right. Call for raised to call for TCR, a scan copy of the TCR.
Additional session just
In
Kamrup.
connection with session case number 71/2024 from the court of Alani. Additional session just comes up. At Aminba. Later matter if it's done, how much will you get? Aminga only.
Yes. I mean,
90. That's it. How
Hmm?
Yes, no.
19th, later matter if it's the 19th of June.
May I please?
Yes.
Well, a regular bail application. Petitioner was arrested on 18/4, 52 days in custody. 18/4, 52 days in custody. What you will find the FIR page 12. Very unfortunate incident.
What is the allegation?
Allegation, allegation is that due to rash and negligent driving of the petitioner, one person died.
Died?
Yes, ma'am. What you will see the annexer, page 12, this is the affair. Mary. Respectfully, I beg to state that on 17/4/2026, the informant is the wife, my lord. At about 12 p.m., while my husband, Sri Jotin Bropatto Gohai, along with our nephew, Vikram Gohai, was coming from Gotiazan towards Titabar on a motorcycle bearing registration number so and when they reached near Bandarsalia LP school, some machinery defects were occurred to the said motorcycle, and while they were repairing the motorcycle, one bearing number so coming from the same direction, driven by the driver in a rash and negligent manner and in a high speed, dashed him with full force, and although the driver fled away, the police.
The Goswami 60 days or 90 days?
My lord, otherwise, my lord, all the sections are available, my lord.
60 days.
60 days.
52 days in custody, up to 10 years, my lord.
Only thing is that the rest and negligence part is there.
My lord, 52 days in custody, my lord.
Let him compare to them.
Yes, please.
Already 52
52 days in
52
custody.
days.
Pardon me, so he actually learned it. Learned it also. Also have some typical showing application under section 4 of ENSS 2023. Paying for bail today, paying for bail in connection with Kitapur Police Station case number traffic 2046 under section 105 stroke 125 stroke 281 of BNS 2023. An FIR was lodged on 17/4/2026 by the informant before the Kitapur Police Station, alleging to telling that that while her husband, namely the Tim Borpatkakwai, along with their nephew, Ritam Borpatkakwai, who were coming from Utiajan towards Tower on a motorcycle, when they reached near Bandor Chalia LP School, some machinery defects occurred on the motorcycle, and they started repairing the motorcycle. That while doing so, one Bolero pickup van bearing registration number AS, it was a Bolero pickup van coming from the same direction, driven by the accused applicant in a very rash and negligent manner and in a high speed, dashed her husband with full force. That is right. So we call that after the accident, the accused applicant fled away. How the police apprehended him with the help of the local people. That during the accident, though her husband was taken to the hospital, he died. He was declared brought dead in the hospital. In view of the aforesaid, in view of the aforesaid, the Kitapur Police, in view of the aforesaid fire, the Kitapur Police Station case number 2046 under the aforementioned sections has been raised against the accused of the learned. I'm sorry. Mr. P. Hazarika, the learned comes very for the victim submits that to the accused applicant. His applicant has already spent 52 days in the 52 days behind the bars, and there was no rational reasons on his part about that because the accident happened due to accident that has happened is purely accident. He submits that he will cooperate with the investigation. Investigation and make himself available when whenever he is required by the investigating officer. Next part, recently Swami Janan at APP opposes the bill.
Paying for bulk.
Histories. This court was heard the submissions made by respected parties and also raised documents that have been placed for this court. Taking into account the fact that the person has already spent 52 days behind the bars. This court is to consider the opinion that at this stage the accused applicant can be released in the list of accordingly. It is directed to the accused applicant shall be released of the receipt of the bail bond of rupees 30,000 rupees here like nature. Which court?
My lord,
The
it is,
satisfaction of
in fact, it is SDGM Chittagong, my lord. Lordship may direct CGM Jorhat also,
CGM Jorhat.
my lord.
The satisfaction of CGM Jorhat subject to the condition for that. Accused applicant shall cooperate with the investigation and make himself available as and when required by the investigating officer. And then like that, these applicants shall not try to influence or influence any witness who may be involved in terms of purpose of based on the
Public.
May I please, Your Lordship? Petition under section 483, Your Lordship. It's an accident case, Your Lordship, where a person got serious injury, Your Lordship. And police has registered it under section 109, Your Lordship, attempt to murder, Your Lordship. Your Lordship may kindly come to the FIR at page 14. May I read, Your Lordship?
Yes.
With due respect, I beg to state that I, along with my colleagues Sri Noyan Das and other person was deployed for patrolling duty near Ganeshguri supermarket assembly area from so-and-so to so-and-so. During the course of patrolling duty at about 4:30 AM on so-and-so, while I and my colleague Sri Noyan Das was working near Assam Tea Auction Center, a blue-colored four-wheeler vehicle coming from 6 Mile side towards Ganeshguri, driven in a rash and negligent and intentional manner violently hit my colleague Noyandas. Due to the severe impact of the pollution, Sri Noyandas has sustained grievous injuries, and from the manner in which the vehicle was driven, it appeared that the driver intentionally attempted to kill my colleague. I tried to stop the said vehicle immediately, but the driver fled away from the place of occurrence. Thereafter, with the help of other colleagues, we immediately shifted the injured to Cosmo Hospital. There from emergency treatment. Subsequently, about 1 PM, he was referred to Gauhati Medical College Hospital for better treatment. At present, he is admitted in the ICU of GMHCH and condition is stated to be critical. I am an eyewitness to the entire incident. Your Lordship may kindly come to the ground of Your Lordship forwarding where ground of arrest has been mentioned, Your Lordship. Page 17, Your Lordship. The accused person has admitted that he is involved in the crime. The accused person drove the vehicle so rash and negligently, deliberately knowing that his act of reckless driving may endanger human life. The accused person admitted that he drove the vehicle at a very high.
Bhattakur will call for the CD in this case. Heard Mr. S. Bhattakur, the learned senior counsel, assistant by Mr. So. Your name? G. Kaushik. G. Kaushik. Heard also heard Mr. D.P. Kaushik, learned ABA for the state. Is an application under section 483 of BNSS 2023 for granting of bail to the accused applicant in connection with this PS case number 326/2026 dated 25/5/2026 registered under sections 109/121 bracket 2 of BNS 2023. Call for the case diary. Let the matter 16.
Deeply obliged.
Lordship, we don't want to press. We don't want to press it as per the instruction of our client.
You have to withdraw this.
Draw it.
Heard Ms. So-and-so, the learned counsel, appearing for the petitioner. Appearing for the accused applicant, also Mr. D.P. Goswami, learned actually for the state. Ms. So-and-so submits that she has instructions to withdraw the instant bail application. The instant bail application is dismissed on withdrawal. Withdraw it.
May I please, Your Lordship? So, with the pre-arrest bail application, Lordship. Lordship, petitioner is apprehending arrest as the police personnel has visited his house while he was out of station, Lordship, and they have informed
Where is
that
the FIR?
the non-FIR bail application, Lordship. Do we have?
Now, what is this trend of non-FIR? I mean, on the drop of the head, they come to the High Court.
Lordship, he has a reasonable.
The drop of the head, I mean, something happens and like some open, he come to the High Court. Without any FIR, without any complaint, without any this thing, I'll dismiss this kind of cases. What application you have?
The police came to my house.
Police came to your house, that they will arrest you.
Informed that.
Go and, I mean, you go and participate in the investigation. If there is something police wants from you, you participate, cooperate with that.
If I appear, there are reasonable apprehension that the
What
police may
reasonable
arrest.
apprehension you have? You don't have any FIR, no complaint, nothing, simply you come to the court.
Actually, report may be called for whether any case is pending against.
No, not,
criminal
I mean,
case
that will
pending
not
against-
be encouraged anymore. Let's see what you have said.
On para 3, Lordship, on case number 2, Lordship.
You have been searching for what?
That we have
Searching for what?
we have not been informed regarding
Then,
that.
then what, then how to, what, I mean, there is absolutely nothing in your petition. Why you have been searching, or you have involved in something, or they are alleging something against you? What is that?
That
Where
has
is that?
That has not been informed to us.
Not informed. You should be aware of some certain things that your relative has said that police has come to
Yes.
the house. Police must have told them, no, what is the reason why they are searching you?
No, Lordship,
Huh?
that
Then
police has not.
nothing is there.
Police has.
I mean, I will not entertain this kind of petition. Cannot
Police has-
entertain. Nothing is there. You don't say anything. Absolutely nothing. Totally blank.
Who lost the affair? Who and what against?
Police is searching, relative has said, and you have come to the High Court. There is no complaint. There is, I mean, one line. What is the allegation against you? Nothing is there. What apprehension you have? You participate. In the police has come. You ask them why they have called you. You cannot file like this. I heard Mr. D. Medhi, the learned counsel appealing for the accused applicant, also heard Mr. D.P. Goswami, learned APP for the state. This is an application under section 483 of BNSS 2023, praying for pre-arrest bail to the accused applicant in connection with a probable Sipsagar police station case. Probable case to be registered before Sipsagar police station. Full stop. The learned counsel appearing for the accused applicant submits that police has visited his visited the residence of accused applicant and he was told by his relatives that police is searching him. Full stop. However, on a specific query by this court, the learned counsel appearing for the accused applicant could not reply as to why he has been searched searched by the police and what is his actual apprehension. Full stop. Taking into account the aforesaid, this court doesn't find any merit in the case, and the SNAB application is dismissed.
Greatly obliged.
I want to withdraw this case. I want to withdraw.
Mr. M. Hawk, the learned counsel appearing for the accused applicant, submits that he has instructions to withdraw the instant case. The SLAB application is dismissed as withdrawn.
Please, Your Lordship. Lordship, anticipated bail application. Lordship, the FIR is filed by Rukmasati Associates on 3rd of Rukmasati Associates, my lord, on 3rd of April 2026 against this petitioner, my lord. And Rukmasati Associates was appointed by Heranba Industries as a clearing and forwarding agent, my lord. On
Yes.
31, my lord.
FIR filed
FIR
by
is page number 21, my lord.
Hmm?
21, 20.
base.
Page number 20 and 21. My lord, as per the FIR, the present petitioner misleading an amount.
Read the FIR.
Oh, my lord. I undersign proprietor authorized signatory of MS Rukmasati Associates having our registered office at house number 14, Sabitri Bhavan, Bailen 1, Eke Azad Road, Rehabari, Gauhati, Kamrup Metropolitan, Assam, and go down at Mahendra Nagar near Child Welfare Committee, Ambari Police Station, Gauhati, Kamrup Metropolitan,
hereby lodge the first information report in relation to grave criminal offences committed by certain officials appointed by MS Herenba Industries under the clearing and forwarding agent agreement dated 05/07/21. Pursuant the aforesaid agreement, MS Rukmasati Associates was appointed as the clearing and forwarding agent for MS Herenba Industries. And accordingly, we took charge of stock from the previous C&F agent 1/07/21. During the internal audit conducted by the company on 6/01/2025, when we requested the opening stock position as on 1st of August 21, when the stock was first handed over to us, it was discovered that there was a difference of approximately 50 lakhs between the stock reflected in the ERP system of MS Herenba Industries and the stock actually handed over to us.
We'll have to go through the CD.
My lord, my point is, my
At
lord,
this stage, nothing can be.
my lord, kindly, my lord, इसमें submission, my lord.
Then nothing can be done at this stage. We'll have to look into the CD.
My lord, in the FIR also is
We have gone
the
through
second
this.
paragraph, my lord.
We have gone through this. Heard, Mr.
J. Abbas, my lord.
Hmm?
J. Abbas.
They are bus, they are on it, council, preparing for the case that happen, also have this of the proposal, there are APB proposed. This is an, this is an, this is an application under section 42 of the NSS, paying for interest to bill with the accused applicant in connection with Potassium somebody PS case number 47/2026, under sections 303, 316, 318, 336, 337, and 61 of BNS 203. All for the city. The later matter fixed on when can
Hey,
be
kindly,
fixed?
kindly, my lord, so I sorted, my lord, kindly. The petition already cooperated with the IM, my lord.
18/6.
18/6.
Solved on 17 or 16 only. There is 8.
Fix it on 16.
My lord, 15, my lord.
16.
Plus, my lord.
Wait, please, your lordship. This is regarding the pre-arrest bail, lordship. The FIR is at page 20. If I may read, page 20, lordship. To the OC New Bangaya GRPS through IC Silchar GRPS. This was a zero FIR, lordships. With due respect, I would like to lodge FIR to the fact that on 9/3/2026, I traveled by ticket number 13175, Sialda Kanchenjunga Express, berth number 64B5, side upper from Sialda to Silchar, white PNR number this and this. The said train departed from Sialda at about 6:50 a.m. of the 9/3/2026. After departure of the train from Sialda at about 7:30 hours, the co-passengers from seat number 61 and 62 B5, as they claim, requested me for exchange from berth number 64 to 62. Initially, I denied, but after repeated requests, I accepted and changed my accommodation from berth number 64 to 62, same cabin, upper berth. During the journey period,
All
we
for the CD.
lordships made
Heard, Mr.
H. Pitala.
Telane comes paying for the accused applicant of Telane is a good official and it for the state is an application under 483 of VNSS for paying of it's paying to the accused applicant in connection with Bongai or BRPS case number 28/2026. Raised under section 123, 123, 305, and 3/5 of BNS 203. Call for the city with the matter fixed on
22nd of June.
22nd of June.
It's an AB road.
Little bit earlier. On
19 and 18.
AB
Bongaigaon.
AB application, huh?
AB application of
19th.
not.
Made me lordships. I'm so blessed.
May I please, your lordship, the pre-arrest bill application, lordship, the FIR lordship will find on page 17, lordship, Patassi farm lordship, page 7.
Who has filed a complaint?
Complaint filed by the tea company lordship, who have given 73 lakhs 97,000 for installation of the solar panel, Lordship. This company or this farm, Lordship, that especially the solar system, Lordship, deal with the solar system, and the tea garden has given paid 73 lakhs 97,000 for installation, but nothing was done, and later on a small amount of materials were given in their company, but the installation is yet to be done. Now, Lordship, what happened? I am here, Lordship. I am the proprietor, Lordship. Let us come to the page page 66, Annexure 4. This is the agreement that will clear the picture, Lordship. The main operator, Lordship, is the Nikit More, Lordship, who is the sole responsible for all this, Lordship. There is a agreement between the proprietor and the Lordship that Annexure 4, page 66, Lordship will kindly see. The Rajendra Kumar Agarwal is the present petitioner, Lordship, who happens to be the proprietor of the farm. The license was issued against him, Lordship, and he have handed over to the that Nikit More, Lordship, that agreement that clearly says, Lordship, on the page 67, Lordship, where is the operator? Yes, in the FIR, Lordship, will found that that they nowhere whisper against this present petitioner, Lordship. Every entire Lordship billing was done with that Nikit More, Lordship, and the payment was also made in into his account, Lordship. That is clear from the FIR. Now let us come to the agreement, Lordship, between these two persons, Lordship, the license holder and the Lordship that Nikit More, Lordship, that on page 66, Annexure 4. That I have gone through. Lordship, that and now, Lordship, whatever notice has been issued to me by the police to APL, Lordship, there is some protection may be given in the meantime.
Case 48, Lordship. A request letter for release the payment from the tea company, Jalan Gauhati tea company,
না, এটা তো হয় feeling, এটা নাকি
to Buildwell Solutions India Lordship. Like he's the sole proprietor of the Buildwell Solution India.
No, I am the proprietor, Lordship. It is admitted fact, Lordship. The license is under my name, Lordship.
Lordship, may I read, Lordship? With reference to the above cited subject, we would like to request you to release payment of rupees 52,27,500 to Buildwell Solutions for a purchase of solar system. Lordship, I prefer at least this
No,
case
Lordship,
there.
kindly, Lordship, they let me produce all these things before the police, Lordship. The entire document, Lordship, the bank account and everything I have checked. Every payment is taken by into his account, Lordship.
Some financial parties
Yeah.
there from the petitioner side, Lordship.
I agree that, Lordship, but the deed of agreement, Lordship, clearly says, Lordship, that he is the main, Lordship, the sole person, Lordship, who runs the entire farm, Lordship. Only license is in my name, Lordship. Notice only till the CD comes, Lordship, let me appear along with all the documents and place before the police, Lordship, the bank statement along with others, Lordship.
Okay, I heard Mr. S. Munir Dalane, counsel appearing for the accused applicant. Also heard Mr. B.P. Pessoa, Dalane appearing for the state. This is an application under section 40.
Notice on page 63.
53 for paying for granting interest to bail to the accused applicant in connection with Gulaga case number 19/2025 under section 61 stroke 314 stroke 316 effective stroke 318 effective of BNS 2023. Case relates to an FIR which was lodged. Where is the FIR?
FIR, Lordship, on page
18.
page 18, Lordship, it starts from 18. And last part, Lordship, on page 23.
Lodged on 7/10/2025 by Jalan Gulaghat Tea Company Private Limited. Lays that in spite of how much money you was paid?
They have paid, Lordship, entire amount, Lordship, 73 lakhs 97,000.
73,93,000.
Paid, Lordship, on 21/6/2025. As per the allegation of the FIR.
What was the amount? 70 lakhs?
73.
73 lakhs?
97,000.
7,000 to the company of to the partnership firm. Was it a partnership firm?
Partnership, no, Lordship, the license is in my name and he runs the Nikit More runs the entire function of the
That I
company.
understand. The Buildwell Solution India.
Lordship.
Buildwell Solution India is basically owned by whom?
Owned by me, Lordship, but the day-to-day function looks after by that, Lordship. That agreement, Lordship, that
Owned by the accused applicant for installation of certain solar panels in the tea garden of the informant. However, the same was not done by, so it was not carried out by the accused by the accused applicant. The learned next paragraph. The learned counsel appearing, Mr. S. Munir, learned counsel appearing to the accused applicant submits that though the company, though Buildwell Solutions India is owned by him, is the name of Buildwell Solutions India has been utilized by one person, namely Nikit More, who is specialized in solar panels and because of his because of his expertise, the accused applicant had entered into an agreement with the aforesaid Nikit More on 10th June 2022, whereby it has been specifically provided that all day-to-day affairs as well as accounts and management of Buildwell Solutions India shall be carried out by the aforesaid Nikit More as he being the specialized person having expertise in a solar work first. He submits that no money has in fact been taken by the accused, taken by the accused applicant in the instant case, and he submits that uh, he will fully cooperate with the investigation if he is allowed some interaction. Mr. D.P. Goswami, the rank APP, on the other hand, submits the case that is should be all for and without perusal of the case that is no interim relief should be granted to the case that was taking into account of the fact that there is slightly heard submissions of both the parties. The council is paying for both the parties, and after perusal of the documents and taking into account the business facilitation and indemnity agreement that it then 6 to enter into between the accused applicant and the proceeding that at this stage an interim relief would be provided to the accused applicant. Accordingly, it is direct. In the event of his arrest, in the event of arrest of the accused applicant in connection with Golaghat Justice number 190/2025, he shall be released on bail on punishing of bail bond of rupees 50,000 to the security of like nature. Nature, the satisfaction of like nature to the satisfaction of the arresting party, subject to the following conditions. The accused applicant shall appear before the investigating officer within a period of 10 days of passing notice order. The accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. Then you write call for the CD, next for call for the CD. Later matter fixed on 26/6. 26/6. 26/6.
Much obliged, Your Honor. Much obliged.
Now, so this is Sashik's case, my lordship, pre-arrest bail application. Sashik page 19 and 20, my lordship. The main accused, my lordship, of got bail 2021 after completing 2 months jail, my lordship. And the no specific act and overt act has been mentioned in the Sashik against the petitioners, my lordship. And the other co-accused also granted released bail 2 months ago by Learned Session Judge Dhubri, my lordship. And FIR is professional 14, my lordship. Alteration happened in the pedophile, my lordship, where the FIR page number 14, my lordship. May I read, my lord?
Yes.
সম্মানপূর্বক বিনীত নিবেদন, এই যে নিম্ন উল্লেখিত আসামিগণে অন্যায় লেঙ্গৰ বলবৰ্তী হৈ পৰিকল্পিতভাৱে মোৰ সৰু ভাই ভোল লেখৰ এৰি ধানৰ খেতি নষ্ট কৰাৰ উদ্দেশ্যে খেতি পথাৰৰ কাষতে ঘোঁৰা বান্ধি থয়। ঘোঁৰাই ধান খেতি খাই থকা অৱস্থাত আজি ইংৰাজী 23/4/21 তাৰিখে সময় দিনৰ 10টামান বজাত মোক মোৰ ভাই ভোলা শেখে খেতিত পানী দিবলৈ গৈ দেখা পায় 1 নং আসামীজনে ঘোঁৰাটো বেলেগ ঠাইত বান্ধিবলৈ যোৱাত আৰু সেই আক্ৰান্তৰে 1 নং আসামীগণে বাকী আসামীজনৰ সৈতে হাতত ৰড লাঠি আদি লৈ দলবদ্ধ হৈ মোৰ ভাইক খেদিবলৈ যায়। মোৰ ভাই প্ৰাণৰ ভয়ত দৌৰি ওচৰত ঘৰ এখনত যায়, কিন্তু উক্ত ঘৰৰ সকলো মানুহে আছিল আৰু সেই সুযোগতে আসামীগণে মোৰ ভাইক চাৰিওফালে পৰা আগুঠি ধৰে আৰু প্ৰাণে মৰাৰ উদ্দেশ্যে 1 নং আসামীগণে ৰথেৰে ভোলাই প্ৰচণ্ড খেদেৰে ঢুকাই বাওঁ হাতখন ভাঙি দিয়ে আৰু মূলত তেওঁ মাটিত বাগৰি পৰে। তেতিয়া বাকী আসামীগণে উঠাই মুঠাই লাঠিৰে কোবাৰে ফলিত তেওঁৰ গুৰুতৰ জখম প্ৰাপ্ত হয়। ফলত সময়ত খেতি পথাৰত কাম কৰা মানুহে কিছুমানে দেখা পায় আৰু মোৰ ভাইক আসামীবোৰৰ পৰা তলা কৰি দিয়ে। বৰ্তমান মোৰ ভাই ধুবুৰী চিভিল হস্পিটেলত চিকিৎসাধীন অৱস্থা হৈ আছে। This is the application, my lord. Charge sheet, my lordship, 19 and 20, my lord.
Seated lordship and conduct. My lordship, trial court observation is case 24. May I read the 11 lordship?
Yes.
On going through the record and the case diary, it appears that the present accused petitioners were absconding during the period of investigation, and the case has been charged by CS number so and so under section 143 for 47427 IPC against the present accused petitioner and the other co-accused. The medical examination report of the injured Bhola Sheikh also reveals that he sustained fracture injury of a shaft of humerus, which is previous in nature, caused by blunt object. On going to the case diary, it appears that there is incriminating materials against the accused petitioners, namely this petitioner Kochi. Considering the facts and circumstances and materials in the case diary, it appears to me that this case is not withdrawn to give the privilege of 2 years to them. So at this is called for a record, Lordship.
It's a bail order, my lordship.
The investigation part, they are not
My lordship, victim
participating
is
in the
completely
investigation.
recovered, my lordship. As for the absconding party is concerned, my lordship, non-bailable offense, my lordship. So how could he without a protection, my lordship, you let it
Regard
be.
Mr. Suresh, London Council agreeing to the accused applicant also urges the application of APT for state. This is an application of the section 42 of the MSS. Intercepting bail to the accused applicant in connection with UBPS case number 665/2021. Registered under section 447, stroke 427, stroke 341, stroke 325, stroke 3027, stroke 34 of Indian Penal Code. There is it is pending before which court?
Well, it is CGM Dhubri. CGM Dhubri, my lordship. It's a parent is small.
Seeking the, then you write next paragraph. Now seeking the instant case has already been filed by charge sheet number 1034 stroke 2021. Dated 30/11/2021. Registered to call for, please the next paragraph, registered to call for that. And registered to call for the TCR in connection with UBPS case number 6665/2021. Pending before from the court from the court of the London CGM Dubai. Next letter preferred fixed on 20th. 22nd of
Deep loveless, man.
22nd.
My pleasure, sir. My lord, in this case, my lord, FIR is not registered at this.
No FIR registered yet.
No FIR is there, but without.
No, we'll not encourage this kind of no affair or some. I mean, whatever happens, you come to the court. Yeah, just tell me which paragraph we have stated your
The paragraph.
how you are apprehended.
Paragraph 3, my lord.
This there.
Police visited my house, my lord. May I read?
What is the allegation against you?
Allegation actually, my lord, one Partho Kolita and present petitioner, my lord. The present petitioner resident of under the Shivsagar police station.
One second, wait, let me read.
Season 4, my lord.
Nothing is there.
Yes.
Some altercation was took place between them, and
Apprehension, there is no, absolutely no apprehension.
actually, subsequently came to know that Partho Kolita, who is the actually informer of police, sometimes police use some individual informer to know the movement of some habitual offender.
With all these vague facts and these things, we cannot allow this.
Well, at this stage, report may be
No,
called.
no, 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 no.
Report may be called for. Police visited and seized my Aadhaar card, PAN card, bank passbook from my house, my lord. And still, I have been directed to appear before the police over phone, my lord. So, there is something, my lord, actually, this Partho Kolita maybe disclose some more facts than actual what happened between them, my lord, before the police. So, police, my lord, visited his house.
Nothing, I mean, only the meeting was there.
At the same time, a report may be called for whether any case has been registered against him, and under what circumstances he has been charged by the policeman. There is no actually the such type of occurrences there. That is true, my lord. But the police visited my house and taken my bank passbook, PAN card, Aadhaar card, and directed to appear before the police.
Mr. Goswami?
Story is not it. A person was asked by this prisoner whether he was there or not.
That is simple.
Thereafter, altercation took place. The story is
There is no apprehension.
no apprehension as they are receiving the story.
There is absolutely no apprehension. You come back, I mean, when there is some apprehension, if there is an apprehension. I mean, we cannot go on entertaining discrimination.
Only because of that, lots of police cannot apprehend anybody.
And our suspicion is that that
Heard
person.
Mr. A.K. Azad, the Learned Counsel appearing for the accused applicant, also heard Mr. V.P. Goswami, Learned AP for SPA. This is an application under section 482 of BNSS 2023, bring for pre-arrest bail to the accused applicant against a probable case that may be that have been registered in Gulaghat police station. The Learned Counsel appearing for the accused applicant submits that he is apprehending arrest since the police has visited his place and seized his Aadhaar card and voter's identity card in his absence from his residence. Full stop. However, he submits that he could not find without any FIR or complaint if any FIR or complaint has been filed before any police station or not. Discord, next Discord has gone through the petition, gone through the contents of the petition. It has been filed for paying anticipatory bail, and this court is not convinced that the accused applicant has any apprehension of arrest in the instant case. In view of the aforesaid, the instant AV application is dismissed.
I'm obliged. So this is my PRS bail application, FI space numbers, 16. May I read
Read.
সন্মান সহকাৰে জনাও যে মই নিকাশী হওঁ 2025 চনত এক্সেবেটাৰখন শ্ৰী দীপজ্যোতি বসুমতাৰী ডেহিত জামাইল পিটিচনাৰ পিতা বহাগৰ মোৰ লগত লিখিত চুক্তিমতে প্ৰতি মাহে 2,20,000 ভাড়া দিম বুলি
Translated version, read translated.
Case number 14 also. With due respect, I beg to state that I am a resident of number 1 Anandanagar, Assam. In the year 2025, my excavator machine vehicle was taken by Sri Dipjuti Bosumutari, son of so-and-so, on the basis of a written agreement executed between us on monthly rental basis for an amount of 2,20,000 per month. That initially some payment were made to me towards the rental charges. However, for the last 5 months, no payment has been made by the said person towards the rental dues. Moreover, the said excavator machine has also not been returned to me despite repeated request and demand made by me that when I personally went to take back the search and the possession of the said vehicle machine, the said deputy Boxumotari refused to hand over the same to me. That as of now, an amount of rupees 10 lakh 50,000 remain due and unpaid towards the rental charges of the said excavator machine. I further beg to state that the said person has disorderly and opinionally sent me, my lord. My lord, this amount, my lord, my lord, disputed, my lord, only remaining amount is 5,20,000. There is a my lord, agreement. Kindly see, my lord, agreement is the my lord, page number 18, my lord. Page number 18, my lord. My lord, the agreement expired on my lord, April. On March, my lord, I informed to the my lord, informant to take back the my lord, but he refused to my lord, take back, my lord. This is my lord, there is the agreement, my lord. There is no my lord. Now, my lord, the police has my lord, issued a notice, my lord, under section 35(1), my lord, at page number 17, my lord. I am ready to go to the police station, my lord. But my lord, the section is my lord, non-bailable in a lordship. So, my lord, I may be protected, my lord. Whatever my lord, payment is due, my lord, I will pay it, lordship. My lord, the 10 lakhs, my lord, in the FIR, they have to release. And my lord, I'm my lord, only 5,20,000 is there, my lord. I'm under.
Okay, heard, Mr.
My lord, dig away.
We go with the learned counsel appearing for the accused applicant also heard. APB Sumi and APB for the state. This is an application under section 482 of BNSS. BNSS praying for pre-arrest bail, praying for granting pre-arrest bail to the accused applicant in connection with Mumbai police station case number 80/2026 registered under section 316 on the case of 318/4 of BNS 2023. And a file next to that, a file was lodged on the file was dated 10
My lord, 10
2026 by the informant alleging that the accused applicant had taken on a rental basis his excavator with the promise of payment of rupees 2,20,000 per month, right? Per month. Though it was alleged that though initially the payment was made regularly, but subsequently the payment was not made, and an amount of rupees 10,40,000 is currently due. I mean due semicolon that the accused that the informant went to meet the accused applicant for getting back the aforesaid excavator because of non-payment. It was refused by the accused applicant. In view of the aforesaid, the instant case has been raised against the accused applicant. The learned counsel, if any further case applicant submits that the amount due is actually not of rupees 10 lakhs something, 10 lakh, what was the amount written? Not 10,40,000, however, it comes to something around 5 lakhs of rupees. And the payments have been duly made in terms of the vehicle rent agreement dated 19th December 2025. He submits that the accused applicant is willing to cooperate with the investigation. If they cooperate with the investigation, right? Generally, after hearing the parties, after hearing the submission made by the counsel appearing for respective parties, this court is of the considered opinion that at this stage an interim relief can be granted to the accused applicant. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant, the accused applicant shall be released on bail or released on bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authorities, subject to the condition that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order, and shall cooperate with the investigation. Next, you write all for the city. Let the matter fixed on.
25/6.
Interim relief I am giving.
Okay,
I am
looks-
giving.
Deeply blessed.
Please, Your Lordship, this is pre-arrest bail. FIR is at case number 9, my lord, translated copy. May I read?
Yes.
The complainant's husband Abdul Ghani Lashkar is a poor daily wage worker and used to go in the various daily markets with a cattle of traders and businessmen and received a meager amount of wage, and with that money he somehow managed to support his family. On 15 to
1 second. On 15 to, yeah.
on 15 to 2026 in a completely plain manner, the accused number 1, 2 told to go to Nitainagar market with some of their cows. The husband of the complainant in good faith left the cows of the accused to Nitainagar market, and the accused number 1 handed over a bag to the complainant's husband. On the way with the bag and cows, the police of Lala police station apprehended the complainant's husband at a place within its jurisdiction. The police personnel of Lala Bajar police station recovered contraband items from the said bag. As a result, the complainant's husband was arrested and sent to jail. As the complainant's husband in jail, finding her alone, the accused person started making various immoral proposals to her. When the complainant refused to accept such proposal, on the night of 31/3/2026 at about 11 p.m., the accused persons entered her house and assured her that they would get her husband out of jail, for which her signature was required. As soon as the complainant came out of the house in good faith, the accused person covered her mouth with the cloth and attempted to commit rape on her by force. When the complainant started screaming for help, the other members of the household woke up and the accused fled here from the place. Further, the accused person threatened to kill the complainant with her children.
We'll have to see the case.
Yes. The case is serious.
We'll have to go through the case. Hard MS when it comes in the case of people. Also, whether it's a DP goes on, then I will please for an application of section 483 of BNSS 2023. Paying for granting anticipatory bail to the accused applicants. Accused applicants in connection with Vilaypur PS case number 9/3006 under sections 331 bracket 2 stroke 64 bracket 1 stroke 62 stroke D51 bracket 1 stroke 3 bracket 5 of BNS also. All for the city.
19/6.
All for the city. Metro 19/6.
Some short date, my lord. 16.
It is from Hailakandi.
It may not come, madam.
16.
So we can put it to 17.
Not 17.
17.
May I please, your lordship, the pre-arrest bail applications as far as it stands. Please stand. Please stand.
10.
My lord. Allegation is theft and housebreaking, madam. The informant most respectfully beg to state that while myself and his family member were sleeping last night, some unknown suspicious person entered into my house unauthorizedly by breaking lock and stolen a big trunk containing valuable clothes and cash. It is to be mentioned that I suspect the involvement of some laborers who are working at my house. 3 persons have been arrested, my lord, and cash of rupees 5 lakhs already recovered. 5 lakhs already recovered from this. I have I am also a laborer, but I was not engaged with that person. Who is the
5 lakhs has been recovered. So you, I mean, your involvement has come out.
No, that other person, that the contract.
Correct.
That is
We'll see the CD.
the short date.
Not heard Mr. Anhop, Government Council, opinion for the accused applicant. Also, Mr. DP to Sumila and APV for the state. This is an application under section 482 of PNSS. Praying for grant of free arrest bail to the accused applicants in connection with Gauhati PS case number 136 of 2026, registered under section 331 in bracket 4 of 305 brackets small a of BNS. So, all for the CD. Let the matter be fixed on
17/6.
76. Thank you.
Met the lordship.
Yes.
Petitioner is the teacher of the school, my lord. He is the high school, and he is the father of the accused number 1. Allegation is against accused number 1.
His
But in fact,
allegation
that's-
is against the accused number 1
Yes,
and he is accused number,
he is accused number 2,
accused number 2.
2 my lord. Page 11 is the FIR my lord. He's the father of that my lord accused number. And they look to paragraph 4 of my petition, I have this in mind. They come to paragraph 4, my lord. What story I have stated. Page 4.
We'll call for the CD in that case.
Actually, in fact, against him only section, my lord, 117. My lord, against him.
There are certain things. I mean, we'll see the CD, we'll keep it a short date, leave it a short date. Lord Mr. H.R. Chaudhary, the learned senior counsel, assisted by Mr. A. Mutin, the learned A. Mohammed, the learned counsel appearing for the accused applicants, also by Mr. D.P. Kusumar, and appearing for the same. This is an application under section 482 of the NSS 2023, saying for granting bail, grant of clearance bail to the accused applicant in connection with Juvenile for PS case number 74/2026 under section 64 in bracket 2. Stroke 351 bracket 2, stroke 117 bracket 2, stroke 35 of BNS 2023. Call for the CD, later matter 16.
Only one thing, my lord, because teacher, my lord, high school, my lord, and actually, in fact, if anything, is the 117 will come against him, which extend to 7 years, my
But
lord.
like there is allegation about assault, and allegation about there are other.
Assault, my lord, her husband assaulted her, my lord. No injury at all, my lord.
We'll see. I mean, next
No
day.
injury at all, my lord.
We'll see. This would like to see the CD.
16.
16/6.
15 of her, huh?
15. Okay.
All right, no.
15.
All right.
P.S. Bellosum, the affair is at page number. Particular is page number 17, Lordship. Type copy is
missing.
type copy is 11.
Yeah.
Page
Read
number.
now. Read now, read.
Yes, Lordship. To the officer in charge, Gauhati Police Station, informant Sri Durga Gutum, mobile number so opposite party, Asaf Ahmed, mobile number so subject FIR. Sir, I respectfully submit that I am the lawful custodian of an elephant described below. The said elephant had been seized by the forest department in connection with a forest case. Subsequently, the elephant was released through the order of the competent court in offense number so and so, dated 23/06/2025. The court entrusted the custody of the said elephant to me. The court further held that no person other than the undersigned has any right, title, or claim over the said elephant. On 16/5/2026, the said elephant was handed over by the forest department while I was bringing the elephant from the forest department with my mouth. The opposite party accompanied by about 10 to 12 persons forcibly stopped us and by intimidating and threatening my mouth and compelled him to get down from the elephant. Thereafter, the opposite party took the elephant to his residence through his own mouth and kept it there. Further, whenever I attempt to recover the elephant, the opposite party threatens to kill me. Lordship. Lordship, in this case, Lordship, on 28/05/2025, affidavit was made, Lordship. By
When there was a court order, when this forest official has handed over the elephant to him, why you have taken the elephant?
Lordship, because of the affidavit annexed to Lordship 28/05,
What affidavit?
he handed over the elephant to the petitioner, Lordship. He handed over the he handed over the custody of the elephant to the petitioner, Lordship.
When?
As per 28/05/2025 affidavit, Lordship.
What is that?
Lordship, I Sri Durga Gautam, Lordship, the informant, Lordship. So and so do hereby solemnly affirm and declare an oath has under Lordship, kindly page number 20.4, Lordship, that in this I am willing to bound to hand over the custody of the above name my elephant to Asaf Ahmed, Lordship. Because of his old age. And Lordship, on 6/6/2025, he also made a declaration, Lordship. It is at page number 21, Annex 3, Lordship. Here he also state that I Sri Durga Kutum, son of late so and so, I have hereby declared that on this day, 6/6/2025, I have voluntarily and with the consent of my family handed over my female elephant named Gozalaxmi, Lordship, to Asaf Ahmed, resident of Balijan, Bokakhat, Post Office Bokakhat, and I shall not claim her back in future because of my old age and various domestic difficulties, and I am unable to maintain and care of the elephant properly, Lordship.
Affidavit was made on 28/5/25.
28/5/2025, Lordship. But court order, as per FIR, Lordship, court order was
23/6/2025.
23/6/2025, Lordship. Before court order, Lordship, he executed an affidavit. And the elephant was also released on 16/5/2026. On that day also he made an acknowledgement, Lordship. Page number 26, last page, Lordship. In Vanagol চুক্তিপত্ৰ আজি ইং 16 মে 2026 তাৰিখে হাতীজনীৰ নাম গজলক্ষ্মী বিভাগৰ পৰা বিভাগীয় বিষয়ে আহি মোক ৰিলিজ কৰাই সমজাই দিয়ে। বৰ্তমান মই এই হাতীজনী 6/6/2025 তাৰিখে ডিক্লাৰেশ্যন যোগে সমজাই থোৱা আউচাফ আহমেদ নিবাস বালিজান বোকাখাটক মই এই অফিচতে হাতীজনী আউচাফ আহমেদক ঘৰলৈ লৈ যাবলৈ এই পত্ৰত চহী কৰি সমজাই দিলো, Lordship. Page number 26. So in this case, Lord.
No, 18/5/26.
He has made all these documents earlier, earlier. So now again, probably he wants it back. That's why he is doing all these things.
Yes.
Then he should go to proper forum for this. Let him go. Heard Mr. DJ Boroda learned counsel appearing for the accused applicant. Also heard Mr. DP Kosami learned APP for a state. This is an application under section 453 of BNSS 2023. Praying for grant of 3 years bail to the accused applicant in connection with Gauhati PS case number 85/2026 under section 310 in bracket 2/310 bracket 6 of the BNS. Right. File was lost on
18/5.
Hmm?
18/5/2026.
18/5/2026 by one Durga Kutum, alleging that he is the legal owner and custodian of an elephant, and the same had been handed over to him by an office order in offense number D/18 of 2025-2026 dated 23/6/2025. 25 by 25, which was seized by the forest department in connection with the forest case. It was alleged that while he was taking his elephant back home, he was back home. About 10-12% possibly stopped them, and after threatening them, they have taken the elephant. They have forcibly taken the position of the elephant or position of the elephant. Was also alleged that though you have not named him, or you have given him now. Yes,
No problem.
It was also alleged that the accused applicant, namely Asaf Ahmed, had refused to hand over the elephant whenever the informant tried to get back the elephant from him. The learned counsel appearing, Mr. Boro, the learned counsel appearing to the accused applicant submits that in fact that the elephant was handed over by the informant himself to the accused applicant by way of an agreement as the informant had become old and he was unable to maintain the elephant himself. Therefore, as a caretaker, the accused applicant has been engaged by him, and there are several documents that effect which have already been annexed with the instant application. He has referred to an affidavit dated 28/5/2025, Annex 2, then write then another agreement Annex 3 and declaration. And another declaration agreement dated 16th May 2026 to support his submission that in fact the accused applicant had been had been authorized by the informant himself for taking care of the elephants.
Disposite of also interim protection also will go to the case.
Correct. I mean, Mr. DP, Swami Dalan, if submits the case diary in the instant case would be required. Would be required for taking into account the submissions made by the Name Council for the parties disclose copies of the considered opinion that at this stage interim relief could be granted. That is applicable. Accordingly, it is directed that in the event of arrest of the accused applicant by the applicant by the arresting authority, he shall be released on interim bail on policy of bail bond of rupees 20,000 with a security of like nature. The inspection of the arresting authority subject to the condition that accused applicant shall appear before the IO within a period of 10 days and shall fully cooperate with the investigation by making himself available as a bail, all for by the IO. All for the city, let the matter be fixed on
25/6.
25/6.
In declare obligers.
Just come back in 5 minutes. Sorry, sir.
Given to us one copy so that we can give it to GMCS for making the DC that certificate. But the thing is that on 4/3/2026 actually a scuffle between a father, mother and the eldest son was there, and in this thing actually the eldest son had killed the father. So on 17/3 he had got a bail actually. Lordship, can I take you to the bail petition on page number 26 and 27? 26 is the bail actually, and 27 the paragraph number 7. After hearing, may I please?
Now, what is to do with the bail here?
Uh, the thing is that he was
What is
given
the relief you're seeking for in this?
I am seeking for the post-mortem report copy should be given to us. We had filed it to the CGM code also, and it was dismissed on 11/5/2026. It is in the page number 23 and 24. From the third paragraph, pursued the record. It appears that
Use the record.
It appears that the case has been registered under section 103(1), 238 and 35 of the BNS involving allegations of a grave and serious nature. The investigation of the case is still at the nascent stage and has not yet reached its logical conclusion. The postmortem report forms an internal and vital piece of evidence in the course of investigation, particularly in a case involving culpable homicide oblique murder, where the nature of injuries, cause of death, time of death, and other medico-legal findings constitute fundamental aspect of the prosecution case. Next, at this stage, through the prime accused has been enlarged on bail. The investigation is admittably continuing. The possibility of involvement of other persons in the commission of the alleged offense, conspiracy thereto, or aiding and abetting the crime in any manner whatsoever cannot be ruled out as this preliminary stage of investigation. The investigation agency must therefore be allowed to conduct a free, fair, and unbiased investigation without any possibility of interference illusions or premature disclosure of the crucial materials collected during the investigation. After this, what happened? The mother was arrested. She was arrested. She was arrested on 25 5 2026, 2 days after she had filed this one actually, and she was given bail. She was given bail on 262026. Here is the copy. And come on the one. She was also arrested and given bail. In para number 3, the, para number 3, the husband of the present petitioner attacked her with a knife and a hammer. On seeing that the son intervened, there was a scuffle between the father and the son, and the father sustained knife injuries, as a result of which he expired. After that, the mother had washed off the hammer and the knife used by her son. Now, number 4, learned counsel of the petitioner had submitted the decision offense under section 238 of the BNS 2023, and the same is bailable.
You are appearing for whom?
GMC.
Hmm?
GMC line.
GMC.
Respondent number 5.
Not getting of the postmortem report.
State, who is appearing state? Who are appearing? I think you can appear for this. Commissioner of Police, officer in charge, superintendent of EMC. Government will be. None is there. I mean, I don't know what.
Lordship, why the postmortem report is now is required is that there are some loans actually, and if we give the DC, the loans is covered by some.
Okay, we'll issue notice, let them come back with whatever the instruction they have. But you say I assume that the learned counsel appearing for the accused, appearing for the petitioner. Also her MS
And Hazarika.
and her
Appearing on behalf of P. Nayak for respondent number 5.
on behalf of
P. Nayak.
and on behalf of Mr. P. Nayak, the learned counsel for respondent number 5. The instant petition that Article 26 has been filed by the petitioner. By the petitioner for directing the respondent authorities to provide a post-mortem report of the deceased deceased late Manish Chaudhary in connection with dispute PS case number 121/2026. Let notice be issued to the respondents. Let notice will be issued to the respondent numbers 1 to 3, 1 to 4 by speed post. Notice and formal notice to respondent number 5 is dispensed with as MS so has put in her appearance on behalf of respondent number 5. However, extra copy of the petition shall be served upon her within a period of 3 days. Then you write, let the matter be fixed after 3 weeks.
Lordship, can I get a
Then you
date?
write steps for service of notice on respondent number 1 to 4 shall be taken within a period of 3 days from passing of this order. Let the matter release 4 weeks. Let the matter release 4 weeks.
Yes.
Lordship, can we get a date actually? Because the thing is that
No,
get.
4 weeks, it will be now it will be most of the space it will be difficult. Next phase we can do so.
Okay.
Once people appear, then we can.
Yes, sir.
Kindly oblige.
In this matter, I have filed an additional affidavit. Perhaps it may not be on record, so I have an extra copy for your lordship. Filed it on Saturday. So your lordship had asked us to get instructions on two primary issues. On the, this is the matter regarding the claim of the petitioner to the subsidy surcharge waiver scheme. So what are the components of the principal amount and why there is a difference in the amount as claimed by the petitioner and the amount claimed by us in the affidavit, your lordship. So regarding the principal amount, my lords, except for surcharge, arrear and current, all other components are part of the principal amount. And regarding the difference, your lordship, that is, if I may take your lordship to, though we have explained it, your lordship, in the affidavit, at paragraph number 4, if I may take your lordship to one of the bills, your lordship, from the writ petition, the bill at perhaps at page number 103, which your lordship had gone through on the last occasion. This is from the Tinsukia Circle.
Yes.
Yes. Now, before taking your lordship to the bill, at the table which is enclosed along with the bill, which starts at page number 92, annexure 16, the details of this particular bill, your lordship will find at paragraph number 6. According to the principle, page number 92.
Serial number 6.
Serial number 6,
Ah.
9107. According to the petitioner, the arrear amount that is to be paid is 31,969. Now, how he has arrived at that figure, I'll just explain to your lordship.
Yes.
Yes. Now, if your lordship has that corresponding bill at page 103, I'm referring to the table at the bottom of the page. Lordship will see there are two components, arrear surcharge and current surcharge, which is 37,240 and 1,383 rupees respectively. What the petitioner has done, he has minused these two amounts from the total payable 70,592 to arrive at the figure, your lordship, of 31,969. Now, the difference which has arisen in the total principal amount as reflected by APDCL, my lords, is because lordship will kindly take a note of one component called adjustment amount.
Where is that?
Just two items above it, above arrear surcharge, adjustment amount of 68,139. Now that is critical. I'll just explain to your lordship. My lords, when an electricity connection is temporarily disconnected for non-payment of dues, then the requirement of the supply code is that such temporary disconnection can only extend up to a maximum of 6 months. Thereafter, the electricity connection has to be permanently disconnected. Now, in the case of the various 187 bills, this 6-month period, your lordship, the electricity was not permanently disconnected. So, though there were no energy charges for those 6 months, demand charges, meter rent, surcharges, they continue to be levied, your lordship. So, since the other items, your lordship, are computerized and we cannot touch them, we have said so on affidavit, there is no scope for manual interference with those items. To give the petitioner a benefit, your lordship, to ensure that the bills payable by him, including surcharge, is only limited to 6 months, an adjustment of 68,139 was given to him in this bill, and similar adjustments were granted to him across all bills. So this amount of arrear surcharge and current surcharge, your lordship, that is reflected by the computer an adjustment against those figures has already been given in the adjustment amount. Now, if we subtract both these amounts, your lordship, the petitioner in effect will be getting a double benefit. Because this adjustment that has been granted to him includes some amount of the surcharge also.
Why some amount of surcharge?
Because for 6 months, your lordship, surcharge is payable. For beyond 6 months, surcharge is payable. For 6 months, your lordship, he has to get that benefit. If your lordship comes to paragraph number 4 of my affidavit, your lordship, it has been explained there.
Photograph affidavit now here.
Now, yes,
Now
that we have filed on Saturday.
But before my learned friend continues with it, ideally, I would like to file a reply to this.
Then let him reply, complete it. You want to reply, file a reply?
Yes, no, this is totally incongruous, Mel. Whatever in submission, Mel, it has been explained the affidavit. It's totally, Mel, out of sync with the records.
No, I can. That's why I wanted to finish. Perhaps then the learned senior.
Then let him file.
Very well.
File one.
Very well.
Reply, then we can hear it.
Very well.
I heard I'm Dr. Galana, Senior Counsel, Assistant Minister. Like they were from the standing counsel for SEDC. Mr. Parker. Yes. And then right like this, PDCL has filed an additional affidavit bringing in certain materials on the court. Mr. Datta, non-senior counsel submits that he would like to file a reply to the additional affidavit that has been filed by the NTPC. Therefore, he prays for 2 weeks time. 2 weeks time. There is allowed legal affidavit. There is allowed legal affidavit after 2 weeks.
My lords may perhaps fix a day because this is otherwise reflected as partnered in the list.
Yes. Today's
Partnered,
yes, it's pattern. Today is 8th, so 2 weeks. Can be on 23rd, Melo? Okay, then 25th, because 26th is the last day. So
it will go to the month of July. Because from the week commencing June 15, this code may not be there.
Right.
For 2 weeks.
Then let it be on 14th or 16th July, Melo. Then let it be on a hearing day, Melo.
It will be on then 16th of July.
16th of July, Melo.
The matter is 16th of July.
Deeply.
My pleasure. Amicus query appeared, Your Lordship. I have to serve extra copy, Your Lordship. Another date may kindly please, Your Lordship. I have to serve the extra copy to the amicus query, Your Lordship.
Mr. Borua is there.
Sometimes before he meet me, Your Lordship.
Okay.
Just present.
Also has to be updated, Lordship. The records need to be updated, Lordship. Because the charges were supposed to be framed on 30th of March. The records have not been updated since then, Lordship. Whether the victim has been examined or not, that has to be informed.
PCR is come.
I apologize, my lord.
You are there. You haven't been served a copy.
No, my lord.
Okay, we'll call for updated PCR. Heard Mr. A. calling the learned counsel according to the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. as well as Mr. A. Borua Dalaran, amicus curiae, presenting respondent number 2. It is submitted by the amicus curiae. Then the amicus curiae that he has not been served with the copy of the application as yet. Mr. Karim, the learned counsel, appearing to the accused applicant, submits the TV shot, the extra copies. During the course of the day.
Yes.
During the course of the day. Register to also the applicant, scan copy of the PCR, the instant case from the court of, which court was this? The court of,
Additional district judge Bilashipara.
huh?
Additional session court Bilashipara.
Additional Supreme Court Vilasipara. Let the matter be listed after 2 weeks.
A date may kindly fixed, your lordship.
2 weeks, let the record come. Or you, okay, we'll fix it on
15 or 16, your lordship.
18 June. 18 June.
Obliged.
My tendency is kindly after some time, mother. I have informed him. My senior is coming, he's on the way, mother.
We also, if I may just point, Pokso case.
This Karim was appearing over earlier. In this matter also?
Amicus curiae is appearing, mother.
Huh?
Can be after sometimes, he's coming, mother. Mr. BK Majan, he's on the way, mother. He's coming from court number 8, mother.
Only thing,
You have been appointed, amicus.
may I submit just one thing?
But was A. Karim involved in this case?
No, mother.
No, his name is not.
26.
This is 26, mother. I think number 26.
Item 26.
Can be after some time. I've informed him. Obliged.
26 को गलत मार्च ये करेंगे अगर तो मार्च ये करेंगे इसका तो तुम काम है तो ये गलत
It is the lordship. For its application, the petitioner is in custody since 2/9/2024, my lord. 2/9/2024, my lord.
29
2024, my lord. And charge sheet has also been laid in this case, my lord, on 20/02/2025.
when
Charge sheet laid on, my lord, 20/02/2025. And charges were also framed, my lord, on 15/5/2025 as per the records, my lord. 15/5/2025.
yes
Yes. My lord,
now what is the space
it is, my lord, no witness has examined till date, my lord. On 19/5, lordship has heard the matter. Thereafter, it was fixed on 4/6. On 20/05/2026, the matter was posted before the trial court, my lord. And then on that day also, my lord, evidence were not recorded as witness did not turn up, my lord. I have obtained a copy from the records, my lord. And here the petitioner seeking his bail on the ground of violation of section 47, my lord, which is at page 35, annexure 6. Either he approached the honorable court, my lord, on the ground of prolonged injustice. I have annexed the bail application rejection order, my lord. And 48 was also not issued in this case, my lord. Page 35 is the notice under section 47, my lord. This is only intimation, my lord, regarding his arrest. And another ground, my lord, is section page 36, my lord. Lordship may kindly put it. Lordship has got it, my lord, page 35, my lord. সার্টিফাইড সার্টিফাইড টু অ্যাপ্লাই করা যাবে ব্যাপারটা তো এটা খুশি না 47 হেডিস করে অ্যাপ্লাই করব কারণ এখানে দিছি সার্টিফাইড মানে
Yes.
Rashid has got it on page 35. The notice under section Malad 47.
That has been given.
Yes, Malad. Only an intimation was there, Malad. There is no such grounds of arrest, Malad.
No, the grounds, they have set it, no, the grounds.
As per Malad, Prabhu Bukas, the paragraph 8, Malad, grounds of arrest and reasons of arrest has been distinguished, Malad.
Then, or you, I mean, as per you are concerned, what should have been the ground of arrest?
But grounds of arrest, Malad, substitute logic correction, Malad.
What should have been there?
The basic material, Malad, which are in the hands of investigating officer or the police officer, Malad, that were needed to be given to Malad, the petitioner.
What basic material? What basic material is to be given to you?
Like Malad, what he has found during the time of arrest, Malad. What are his involvement, Malad, in the present case, Malad?
What was the material seized?
Malad, it's a 102 kgs of ganja, Malad, from a vehicle truck, Malad.
Regarding 47 notice, Lordship, when materials have been recovered from his position and which has been kept in a secret chamber. So, Lordship, that for 47 notice, which has been given to him, that is sufficient because he is fully aware what he is doing and why he has been arrested.
This is the mandate of the Supreme Court.
That is not the because the Lordship in prior to that, Lordship, Bihan Kumar arrest, Lordship, this is.
You tell me what is it? That is the mandate of the Supreme Court.
That is not
That
the-
something has been recovered from him, you need not give the grounds of arrest.
No.
And arrest,
Regarding 48 notice that I have not found.
arrest memo.
Yes, Malad, page
Yes,
36, Malad.
No, no, so regarding arrest memo, Lordship, that because he is from another place and so Lordship,
What about a witness?
witnesses part Lordship, that is there in as a WT message has been sent Lordship. Even though Lordship, is 48 notice was there, then we can argue, but 48 notice I have not found in the PCL.
48 notice is not there. 48, if 48 notice is there also, 36, you cannot waive of 36.
Yes, Malad.
Now, I mean, while arresting him, all this.
Copy notice given.
Right, sir. Okay. So, paragraph. Paragraph 11.
Forty-eight notice has not been given. I have not found it here.
48 notice not there, 47 notice was not properly done. 36 notice is not complied. Okay. The right, heard Mr.
MH.
Also has to set PS factor and an activity for this. This is an application in the section 480 of the NSS for example, playing for and paying in connection with special and component for rising out of Bazari Chera PS case number 6146 for registered number 620 bracket small b bracket small 2 and then C is 25 stroke 25 of NDPS Act 1985 1985 pending in the court of law special case of removed. Where is the earlier order?
Earlier order is at page, my lords. Page 23, my lord, 28, my lord, Annexure 4. Page 29 is the submission and findings of.
Delegation in the laws by police, FIR lodged in Bajaj police station on 2/9/2024, alleging that the total amount of 102 cases of Punjab was seized from the truck, which was driven by the the accused has had on an earlier occasion approached this court for granting bail to buy bail application number 3587/2025. By this court on 2/2022. This year, the inspector has under been received this. The learned counsel preparing for the case of submits that in the instant case, no proper service of notice under section 47 that the accused was done was that he submits that no grounds have been specifically mentioned in the notice issued by ENS as to the accused applicant. He further submits that there is also violation of section 48 of BNSS as no such notice has been issued to any family member or relative or a friend of accused against the case. He further submits that there is also a violation of section 36 of BNSS has no attestation from any witness or any witness, either a respectable person from the locality or any of his relatives has been taken in the arrest mode that has been prepared under section 36 of the BNSS. BNSS while arrested by accused of cricket. He surveys that there are catalogue of cases of the Honorable Supreme Court as well as this of this Gauhati High Court, wherein it has been clearly laid out that any violation of the mandates of BNSS under section 36, 37 of 8, the same then the arrest itself becomes illegal and a person shall get a right to be released on bail. That's the this yes, perfect element. Repeat because it submits like a huge amount of commercial quantity, a huge amount of ganja, which is more than commercial quantity plus recovered from council's position of the accused and they are taking into that aspect of the market. The player of bail should be exact. This court has produced and result any notice under section which has been issued to any of the family members. While perusing the section 36, Arizona scope of not any feature of any inspector person or the accused of it's a 48 months. 48 months, wherein the council is required to provide to the use the people is also not in terms of the second about which one. Taking into account the PROCEED violations, mandatory violations, while arresting the people or the arresting for scrutiny of the principle of these days, that should be released on bail. According to these direct, the accused that people should be released out of jail on punishing of a bail bond of rupees with 2 series of life nature of the district concession gas. District concession gas Sribhumi.
Sribhumi, yes, special gas Sribhumi.
No, Lanet special gas Sribhumi. Special gas Sribhumi. Subject for which they used, we can say cooperate with the crime and we and make himself available for the trial as a more powerful. Is that shall not that clause no when then these applicants shall surrender his shall provide his that ID card and listing in terms of in the opposite term the instant communication
Keep your letter.
May I please also 483 application, I said on
4/4/26, and he was granted interim bail by this court on 8/4/26. The case diary was called for.
CD, we have not received also.
For so many, almost 2 months now. On last 8/4/26, he was granted interim bail by this court. And after 2 months, 2 days. And so far, the co-accused is concerned, he was granted PRS bail by the Darwin Sessions Court on the ground there is because there was no updated CD. That your loss will kindly see. Last update was on 23/4.
Last
Is the
chance may be
main
given
culprit.
also.
The co-accused is the main.
One last
culprit.
chance may be given.
That you'll also kindly see because case there was updated till 23/4/26. And there was no updation after that.
He is on interim lordship.
That is all right, but 2 months has gone by.
The person?
He is Sukumar Sama. He is the main culprit. He has assaulted with the beer bottle. And the petitioner is an advocate. He was there along with him. At the time of incident, he fled away. Thereafter, he approached the Honorable Sessions Court and granted PRS bail.
Yes, Mr. Lockhart, what is to be done?
One last chance may be given lordship because he is on interim lordship.
The interview is there, but like why is the CD is not coming?
That too from Dispur only.
They are not.
Day after tomorrow lordship may kindly fix. I will try to bring, if not then lordship may pass any other. Day after tomorrow lordship may kindly fix.
Let him go. Nothing is there. I mean, the offense is also, I mean, small offense. Nothing big. Fight with beer bottle.
Fight with beer bottle.
Okay, heard Mr. D. Kalabdar and senior counsel. This is the
It's okay.
Also heard Mr. P.S. Lockhart, the one at KPP for the state. This is an application of section 480 of the UNSS. Failed for grant of failed connection with dispute PSS number 19 respective locations tested of such 109 stop 118 in the of 5 years. The case affects living in a text affects narrative to have everything. 4/4/26 lost by 109 that if on that on 4/4/26 while the picture while and under the tumor summer when consuming alcohol that is at the bomb at the mentioned place in the fire. They assaulted one Lut Mehdi and Lut Mehdi or Mehdi.
Mehdi.
Huh?
Mehdi.
With Mehdi and Hidoidas with alcohol bottles. As a result of which they sustained injuries and had to be admitted in hospital. By order dated 8/4/26. interim relief, given the interim relief is applicable with the direction to cooperate with that investigation. Is that in the instant case was possible? How though sufficient time has elapsed, with the not support not report is in the matter was part. So yeah, we can look at the so these the main is increase much like it's already done by the additional by the learning additional session was in the before coming Gauhati by 3 5 just the other submits that the offense with other submits that the submits that the accused is a law abiding citizen and he was in fact not all alleged incident that has been narrated in the FIR, which he submits that in terms of the order to secure the accused applicant has already appeared before the investigating officer and got his statements recorded. This leads everything into account is conduct. His conduct his interim days should be made absolute excuse. So yes, but submits that this day is required to the matter and we work those is very respectful but the interim data is a absolute which it is put for the submissions made by the council appending to the respective party and after provision of the materials of the police court is of the considered opinion that the accused applicant that the interim order passed on 8/2026 should be made absolute at this stage, absolute at this stage. Accordingly, the interim order interim period is below by the 8/2026 is made absolute in the same terms and conditions as mentioned in the order dated 8/2026. In the above terms, the incendiary application is disposed of. In the incendiary avail application is disposed of.
Macho.
May I please, Your Lord? Sorry, my lord, I was not there on time, my lord. Here, my lord, with all respect, my lord, this lordship has dealt with earlier, my lord. May I first draw your lordship's attention to your lordship's earlier order rejecting the prayer for bail.
Yes.
At the outset, my lord, with all respect, my lord, reading the FIR, reading the 164, 161 statement earlier, my lord, and now, my lord, the evidence on record, my lord, it is a 7-year period offense, my lord. But the section of law that has been attributed at the time of framing of charge, 65(2), my lord, with all respect, my lord, is redundant and cannot be made applicable to the case, my lord. And lordship's rejection order that occurs at, my lord, with all respect, my lord, page 51, my lord. Relevant paragraph, my lord. Page 51. May I read it, my lord?
Please.
51, my lord. It begins at 49, my lord. 51 is the relevant paragraph, my lord. Para 8, my lord. May I read, my lord? This court has heard the submission made by the counsel appearing for the respective parties and the above considered the material available in the trial court record. After the perusal of the trial court record and having found prima facie incriminating materials against the accused applicant in the offense so alleged in the FIR, absolutely, my lord, so alleged in the FIR, also taking into account
of the fact that many of the important witnesses are yet to be examined before the learned trial court, this court is of the opinion that it is not the right stage to give the privilege of bail to the accused applicant. That is 4 months back, my lord. And my lord, lordship's observation is very correct, my lord. One line, my lord. Having found prima facie incriminatory against the accused in the offense, so alleged in the FIR. Have I made my position clear, my lord? If the FIR is read, my lord, may I come to the FIR, my lord? That occurs at page 17, my lord. And why this has been done by the child, my lord? Some transfer issue, those are immaterial at the moment, my lord. 17, my lord. If it is read in totality, my lord, with all respect, my lord, that is, my lord, earlier 354, my lord, touching, my lord. With all respect, my lord, no ingredient of 65, it cannot be, my lord. Even the evidence I'll read out, my lord. Page 17, if it is read in totality, my lord, one girl, with all respect, my lord, very bad, my lord, that should not have happened, assuming it happened, my lord. Touching the girl, my lord, fondling, my lord, to be very precise, my lord. And now coming to the evidence of the mother and the child, my lord. Mother's evidence, my lord, with all respect, my lord. Page 59, my lord. Correlation 59. 59, my lord. I'm taking a minute, my lord. 59, my lord. From my lord, with all respect, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 11, 12, 13, 14. 15th line, my lord. With all respect, my lord. Daughter's friend, lordship may have found, my lord. 1 second. 16th line, I'm sorry, my lord. Friend Tulika Dotto came to my house and told me. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Read from the top, no? 59.
I'll read from the top. Taken him inside to show our house. My daughter at the time was alone in my house and going inside the house. The headmaster stayed inside our house for about 15-20 minutes. He also stated that after the headmaster left our house, my daughter came out of the house and was looking very sad and depressed, whereas earlier she used to be very happy and jolly. Then I went inside and asked my daughter whether Ram sir had done anything to her. Then she told me that he had done nothing and that he had invited us to his house to have rice. However, she avoided looking at me directly. At that time, her school was closed after her exam and result was not yet out. From that day, my daughter did not seem to get up from the bed, not wanted to have anything to eat. On the next day, around 4 p.m., Ritumoni Dotto, my neighbor, and the mother of my daughter's friend Tulika Dotto came to my house and told me that, this is important, my lord, that my daughter had told Tulika that the headmaster has put his hand inside her sporting and touched her breast. Then I asked my daughter whether the fact was true, and she told me that it was true. Then I called for a meeting of the Nari Surokkha Committee and also VDP party. The accused was called at the meeting and he admitted his guilt. My daughter also stated the fact was true. This is the allegation, my lord. Here's, with all respect, my lord. So far as the mother's evidence is concerned, my lord, then thereafter the girl's evidence, my lord, page 66. Duplicating the same thing, my lord. Very unfortunate. If it had happened, it should not have happened, my lord. 66, my lord. My lord, from the top, my lord. Lordship may happen 66, my lord. Headmaster put his hand inside my clothes and touched my breast. He told me that I was going away from the school and it was my last year and will not be able to touch me. So he was touching me then. He touched my breast for about 15-20 minutes. Goes on and on, my lord. Then a meeting was called by the mother. It's exactly the mother's story, my lord. Now, my lord, the section of law attributed at the time of framing of charge, with all respect, my lord, the order framing of charge, my lord, with all respect, my lord, occurs at, my lord, page 37, my lord. Page 37, my lord. That is possibly an error has been committed, my lord. Charges have been framed. It should have been framed under section 10 of POSCO. What a quantum of punishment provided is down below 5 years. Above, my lord, it can touch 7 years, my lord. Here, my lord, at the time of framing of charge on the basis of this evidence, my lord, 37, my lord, first, second, third, fourth, fifth paragraph, my lord. It appears that there are sufficient ground for presuming that the accused Ram Khoikia has committed offences punishable under section 33 to 74. These are, my lord, possible, my lord. But 65(2), my lord, it can under no circumstances can be at play, my lord. May I just come to 65(2), my lord? And also 10 of POSCO, my lord. 10 and 11 of POSCO, my lord. 10 is absolutely applicable. But 65(2), my lord, relates to rape, my lord. 65. Two mile.
Yes.
I'm sorry, my lord. Two, Lordship may have found out, my lord. 65(2), my lord. Whoever commits rape on a woman under 12 years of age shall be punished with rigorous imprisonment for, my lord, rape. There is no ingredient of rape, my lord. And, my lord, that is why there are 354 earlier, my lord. My lord, outraging modesty of a woman, my lord. Major or minor, my lord. That is why, my lord, the other sections have been put, my lord, with all respect, my lord. So 62, all these sections are there, my lord. So 65(2) out of the blue, my lord, there are no materials, my lord. So it is a 7-year maximum offense, my lord, coming to POSCO 10, my lord. May I just read it, my lord? Ten, my lord, with all, sorry, my lord. 10 punto hai, will you? 10, my lord. 10. Punishment for aggravated sexual assault. Whoever commits aggravated sexual assault shall be punished with imprisonment of either description for a time which shall not be less than 5 years, but which may extend to 7 years, and shall also liable to fine. So, my lord, definitely, my lord, the bad thing that should not have happened. But quantum maximum at the end of trial, with this evidence, my lord, and the factual matrix, my lord, he can be punished to the extent of 7 years, my lord. And possibly this, my lord, may not have, I do not know, my lord, may not have been pointed out to your lordships at that point of time, my lord. Now, my lord, with all respect, my lord, he is there after your lordship's rejection, he is there for 4 months. My lord, even a single default should lead to his cancellation of bail, my lord. Total 14 months, my lord. That is 426 days, my lord.
So we'll take it up to.
My lord, my lord.
Krishna Bora. At the time, this girl was there. He is about 12 years of age. Suren Bora, whom I call Bordeta, was working outside our house in the compound doing carpenter work. Around 2 p.m., the headmaster of our school came to our house and I told him to sit in the veranda. But he wanted to see our house, so I took him inside our house to show our rooms as it was newly constructed. My friend Krishna Bora also came with us inside our house, but the headmaster sent him away, asking him why he came inside. When he went outside, the headmaster put his hand inside my clothes and touched my so. He told me that as I was going away from the school, as it was my last year and will not be able to touch me, so he was touching me then. He touched my so for about 15 to 20 minutes. Afterwards, I came away from the room and told Krishna Bora about the incident. I told Tulika, another person, Tulika, about the incident 4 days after the incident when she came to our house. Then Tulika told our mother about the incident and her mother told my mother about the same. Then my mother asked about the incident and I told her about the same. I had not told my mother about the incident earlier out of fear. Then a meeting was called by my mother in library regarding the incident. In the meeting, I, Krishna, and Tulika were also present. We were also asked about the incident in the meeting and we stated about the same. In the meeting, the headmaster was also present and he admitted that he had committed the incident. Then my mother lodged the FIR, report of police station. Regarding these persons were present. One Narayan Saikia was also present, 67, at the place of occurrence. No doubt they are not the eyewitness. They have not directly seen the incident because she was taken to the bedroom of her house. Page 67, Lordship, during cross-examination. Devakrishna and Tulika are my best friend. The headmaster used to teach us from class 1 to class 5. He used to rebuke us when we remained absent from school and advised us to become good people. He used to teach us English. In my school, there was two other sir, namely Bolin Soikia and Pramodar Soikia. On the day of incident, my grandmother was also present in my house. His name was Narayan Sekia. This is one of the witnesses. He was sleeping in his room. Our house had been newly constructed. Our house has 3 rooms. One of the rooms, which are these are not related, Lordship, para 9. On the day of incident, the headmaster had come to my house. This is admitted fact, along with Pramodar Soikia, sir, and I then told them to sit in veranda. But when Pramodar Soikia, sir, came to know that my mother was not at home, he went to another house to inform about a meeting. When the headmaster and Pramodar sir had come to our house, I, along with Devakrishna Bora, were playing music and dancing in the room of our house. As we did not hear them calling, my grandfather came out of his room and told them to sit in the veranda. Then headmaster went and brought us out to the veranda by holding us by our shoulders. Then we sought blessing from them by touching their feet. After coming to know that my mother was not at home, they went away to others' house to give information regarding a meeting. After about half an hour, the headmaster again returned to my house, that is the petitioner, and I told him to sit in veranda. Then he told me to show the rooms of our house. Hereafter, there is no cross-examination, Lordship. The actual facts, the allegations, there is no cross-examination, just suggestion has been given. Nothing has been put to the witness that he has not committed the offense. Lordship, from the evidence of this PW, the victim girl and the mother, the learned counsellors read over before this court that offense has been committed. Maybe it is not under 65(2) of the IPC, BNS, but the offense under POCSO Act, the victim is of 12 years, is under 12 years. So offense has been committed and trial is going on. As per information, 7 witnesses has been examined. Now, Lordship, these witnesses, some of the witnesses were not examined. So
Devakrishna Bora is examined.
But it was as I have. The statements were same, Lordship, as per victim has stated, and before them, this headmaster has admitted his guilt, Lordship. And these are the merit of the case, Lordship. And as the trial is going on, Lordship, and the length of detention in POCSO case, Lordship, will not do, Lordship, for getting, that is not a ground for bail, Lordship, in POCSO case. As the trial is going on and witnesses examined and incriminating materials comes on evidence on record, Lordship, there is no cross-examination to discard the evidence of this victim girl who is aged about 12 years of old. And presumption is there under POCSO Act. So that is my humble submission, and I leave it to the Lordship. But there is merit, there is incriminating materials against this person, and moreover, Lordship, this person is the headmaster, and some of the witnesses were his student, Lordship. If at this point of time he come out from the jail, Lordship, then there is possibilities to influence these witnesses, Lordship, and other related persons of that school.
Examination.
Page 59, one statement has been pointed out by the learned counsel, Lordship. Page 59, the statement, evidence of PW1, that is mother, Lordship. Page 59, Lordship. The accused was called at a meeting and he admitted his guilt. My daughter also stated the fact was true. That is in the evidence of PW1, that is the informant. And Lordship, if he is able to shift his burden, Lordship, presumption against him at the defense stage, then he may get out of jail, Lordship.
What did you say?
Lordship, as there is evidence, there is no cross-examination with regard to the credibility of the witness, the statement made by the witness. He has admitted his guilt. That is come on evidence on record of the witnesses, and the under POCSO Act presumption is there, Lordship. And during defense witness, if he places or adduce any evidence to show that he was not guilty or he is not connected with the offense, then he may get the relief from the court, Lordship. But at this stage, Lordship, there is implementing material. There is chances of influencing the witnesses, tampering with the evidence. The witnesses, some of the witnesses are of his student. So at this stage, Lordship, I'm submitting my submission, Lordship.
Look, may I add a line? May I add a line?
Yes.
May I, my lord? My lord, this is correct, my lord. Assuming, my lord, whatever she has said is absolutely correct, my lord, then he would be convicted, my lord. That would be 7 years, my lord, with all respect, my lord. Out of 27, 7 witnesses have been examined, my lord. And, my lord, it is influencing witnesses, my lord. He's 59 years, he'll never get his job back, my lord. With all respect. Have I made my position clear? So, not even after 2 months, he'd be otherwise also superannuation. Now also he cannot join because of the case. That is a tampering with evidence, possibly not possible because the reason, my lord, mother, my lord, and son, there are no other eyewitnesses, my lord. They have already been examined, my lord. And one thing, my lord, Parsi, my lord, it is a 7-year period offense, my lord. 7-year period offense, my lord. When it is 7-year period offense, my lord, even after conviction, my lord, Lordship knows more than me, my lord.
No, yes.
Fixed sentence, my lord. Assuming he would be convicted as per her, whatever she is correct, my lord. Now it is a case for conviction, possibly, my lord. In that event, my lord, it will be a fixed term, my lord. Even after conviction, when he is entitled to bail, my lord, because fixed term, my lord, 7 years. But now at this stage, my lord, if he remains there, that is to, my lord, with all respect, my lord, to prepare for his defense. My lord, and keeping him in jail would not help anything, my lord. With all that is not the mandate of law, my lord, and that is not the Indian criminal justice delivery system. And my lord, had it been, my lord, one day more than 7 years, my lord, have I made my position clear, my lord? Possibly this prayer should not have been made, my lord. With all respect, my lord. And whatever is the submission, it is absolutely true that cross-examination is also not of very sterling quality, my lord. So there may be conviction, so far as this evidence is concerned, my lord. And that itself is a good ground for getting the benefit of bail because it is a Parsi 7-year period of its mind. And only one girl, my lord. It is not a series of girls, my lord.
Okay, I'll just go through it.
My lord, as your lordship, please.
May I, Lordship? As there is possibility of conviction, as learned counsel has submitted, and as it is a POCSO case under POCSO Act, as there is presumption of guilt of the accused,
Yes.
and as there is higher possibility to influence the students of the petitioner, who was the headmaster of that school.
The students have already been examined.
Uh,
Those two,
students
Devakanta, Bora, and
Devakanta examined, my lord.
Lika, they've been examined.
Tulika was also there.
Tulika and Devakanta examined, my
And
lord.
those two are the vital witnesses.
If students were examined also, I have not seen properly the record, Lordship. Other witnesses who were worked in that school, they may be influenced.
No, see, already mother, victim,
Tulika and Devakanta.
mother, And the two are vital witnesses
Yes.
who had been disclosed by the supposedly disclosed by the victim were to these two, one boy and one girl, and they have already been also examined.
And Lordship, there is possibilities of conviction.
Yes, there is.
There is evidence on record. So,
But whether that is a ground to keep him, keep him inside the jail. I'm just asking you. I mean, like, I have not decided anything.
Lordship,
If somebody is going to be convicted, may be convicted,
yes,
I
Lordship.
can't say, may be convicted, then whether that is a ground to reject a bail.
Considering the gravity of offense, considering the gravity
Yeah,
of
gravity
offense,
of offense.
the general law and the POCSO Act objective is different, Lordship. In general IPC offenses, other offenses, we can consider the bail application on the ground of the inculcation of the petitioner. But this is a POCSO Act, 12 years old girl of
7 years maximum punishment.
maximum punishment 7 years, but it is under POCSO Act.
Yes, I understand.
So maybe Lordship 2-3 months case may be disposed of, Lordship, as it is of 25 case, 2025 case, now 2027 witnesses has been examined.
My lord, she is correct, my lord. Even in that event, my lord, 27 witnesses, 7 have been examined. Vital witnesses, first informant and victim examined, and the rest 2 witnesses who are named, they have been examined. And my lord, if she is correct, and she is possibly correct, my lord, till now, whatever evidence has been adduced, it may be a case of conviction, my lord. So it cannot go beyond 7 years, my lord. Have I made my position clear, my lord? When it is fixed period, my lord, I should not place those laws, my lord. Because, my lord, when conviction is there, my lord, fixed period 7 years, my lord, even appellate stage, my lord, bail is a matter of right. And what she has said, my lord, in POSCO, there is no embargo like an NDPS, my lord. Have I made my position clear, my lord? Statutory embargoes are not there, my lord. My lord, whatever be it, my lord, fixed period is fixed period. Even I should not say, my lord, even in a case if the girl is a prosecutor is of around 12 years, my lord. Because the section provides, with all respect, my lord, section 10, my lord, it can only touch 7 years, my lord, maximum, not beyond it, my lord. So it would be like any other offense, my lord. And it is, my lord, so far as the victim is concerned, my lord, single victim, my lord, not that a class teacher, my lord, doing everything wrong things with every girl. Have I made my position clear, my lord? It's a single girl scenario, and that too, my lord, with all respect and folded hands, my lord. Lordship would kindly peruse the record, my lord, with all respect. And my lord, like NDPS, here, my lord, no statutory restriction is there. So far as bail need not be granted because of a child is involved, my lord. With all those restrictions are not there. The intention of the legislature is reflected in the statute, my lord. And in the statute, no embargoes are there, my lord.
Section 29 is exception, Lordship.
Section 29 POCSO.
Presumption as to certain.
Presumption is there.
7 years. It presumed also, I'll be there for 7 years.
Or abetted or attempted to commit the offense as the case may be, unless the
Presumption is there. He's talking about statutory embargo. Is there any embargo? Presumption is there. Presumption is there, and trial will go with that presumption. That section is already there, and maybe convicted also. The only thing is that whether only somebody will be convicted, that can be a ground.
No, influencing part is there, tampering with the other witnesses.
I'll just
My lord.
pass the order.
My lord.
Okay.
The petitioners, my lord, in judicial custody for 87 days lordship and 82 days lordship. My lord, now for various days CD was called for lordship. On 2nd of my lord this month lordship date was fixed for CD. Actually CD was there lordship, but CD was the available lordship in the office lordship. But I don't know why it was not produced lordship. It said that the CD is not there lordship. Now anyway lordship, today's 87 days lordship already, my lord. This statutory period is going to be over lordship. Charge sheet is 90 days lordship. Charge sheet is not yet filed lordship.
Lordship, earlier that lordship, a reporter called from the Ames lordship
That report we have not received yet. CD is lying here also. That's why the report is not received. And as my calculation is 84 days today. Because forwarding is 16 3.
11, forwarding 11-3, not 16. No, correct. 11-3.
20 to 24.
One is 16-3, two is 11-3. So 87 days and 92 days loss.
The report is not available, no? AIMS report
Yes,
sometimes.
not, that is not available here. Okay.
Then, my lord, in other case, lordship, cross case, my lord, charge sheet is submitted. On
cross
that
case-
ground, lordship, on that ground, case number, my lord, 3 lordship, interim bail is granted by the coordinate bench lordship.
The cross case charge sheet certificate, that was.
My lord, once cross case is submitted in the charge sheet, lordship, in cross case, charge sheet is submitted, my lord. There, my lord, it is my lord, prima facie case, there is that the police has found, my lord, the prima facie case against them, lordship. So the case is, my lord, there's a group fighting, lordship, this and that man. Unfortunately, a person was, my lord, died from that group, lordship. A plaintiff and defendants, lordship. In this case, lordship, we are from my lord, plaintiff side, lordship, and they are from defendant side, lordship. Because of, my lord, second paragraph, lordship. Near 2 days, 87 days, the 2 days, 3 days ahead is ahead, lordship. Now, length of detention as well as, my lord, other may. CD is there, lordship.
Yes, Goswami?
But the only thing is that the report is not available with us.
No, I mean, it
The
is
sufficient
87 days is gone.
materials are there already. That is the reason.
57 days are already gone. Heard Mr. Amit Ahmed Lani conflict opinion today. How many people are there?
2 petitions.
Two please not others.
The accused applicants. Also heard Mr. D.P. Goswami and an EPP for the state. And Mr. R. Islam.
MH Ahmed.
Huh? Your name? Huh? J? J. Uddin. Millennial Council correspondent number. Correspondent number 2, informant. Your MH has Ahmed, na?
MH Ahmed, lordship.
An FIR was lodged on 7/3/2026, alleging trespass at Ashok. Alleging trespass into the land of the informant by the accused persons. In bracket, we write 14 persons named in the FIR. Accused persons, and they are assaulted. Thereafter, injured the informant by severe assault on them. Semicolon. It was also alleged that due to such assault, the father of the informant expired. A cross FIR was also filed, which resulted in registration of Dolgaon Police Station, case number 47/2026. And one of the persons from the side of the accused have also sustained injuries on his head. The learned counsel appearing for the accused applicants submits that in the cross affair, the charge sheet has already been submitted against the accused persons therein. This person therein, in he can like a cross case, a charge sheet has been already filed in the cross affair. That is Dolgaon PS case number 47/2026. He submits that the accused applicants are already behind the bars for last 87 days, and charge sheet is yet to be filed in the same case. Therefore, taking into account the length of detention, the accused applicants should be granted bail this stage. Also, Mr. D.P. Goswami, along with APP, on the other hand, opposes the bail the accused applicant, stating that there are sufficient improvement in materials against the accused applicants, and in the incident involved killing of a person. This court has the case there in the instant case has been reduced for this court, and the same is reduced after appraisal of the case diary and taking into account the materials brought before this court, as well as the fact that the accused applicants are already behind the bars for last 87 days. This court is of the considered opinion that the accused applicants should be released on bail at this stage to stop. In view of and therefore, it is directed that the accused applicant shall be released forfeit on bail by furnishing of bail on rupees 30,000 each with a security of like nature. The suspension of the which court is this?
Learned Cesium Dorong Mongol.
Anesthesia?
Dorong.
Dorong?
Mongol.
Mongol. Subject to the condition that the accused applicants shall cooperate with the investigation and make themselves available as and when called for by the investigating officer. In terms of the opposite direction, the instant bail application is disposed of. So CDP is submitted.
Wait, please, Your Lordship. Lordship 483 bail application. On last occasion, Your Lordship, TCR was called for.
Your Lordship, the TCR has been received. It appears, Lordship, that charges has not yet been framed. Only cognizance has been taken so far.
Lordship, FIR is at page number 10, Your Lordship. May I kindly read the FIR also? FIR at page number 10. 483, 52 days behind the fire. May I read the FIR, Your Lordship?
Yes.
Subject Ajhar. Sir, with due respect, I'd like to state that on the night at around 2 a.m., the opposite party set fire to my house. The incident has arisen due to a long-standing quarrel between my sister's husband and the accused person because of an extramarital affair involving the accused's wife. In a fit of aggression, the accused committed the act of arson, resulting in the destruction of Gautam Ghosh's shop by fire. With the help of local villagers, I managed to extinguish the fire. However, property damage amounting to approximately rupees 20,000 was caused. My father witnessed the accused fleeing the scene after the fire was set. Therefore, I request you to kindly take appropriate action. Your Lordship, here the motive has been said that there is an extramarital affair between one's wife and this accused person, and therefore the entire fire was there. Lordship. The only eyewitness is a 67-year-old man who claims that he has seen him fleeing from the spot at 2 a.m. in night. Your Lordship. However, in the FIR starts saying that he has set my house on fire, but later on it turns saying that there is a shop nearby which was caught on fire, Your Lordship. However, only in 4 days, the police has filed a charge sheet wherein there is no report from the fire department which says whether there was a fire in reality or not, Your Lordship. Our humble prayer is that there is no fire which has occurred.
Why the report from the fire authority is required?
No, Your Lordship, I'm not.
Not investigate?
The police can investigate, Your Lordship. Within 4 days, they filed a charge sheet.
Why forest department, okay, this fire department?
Your Lordship, because there, as per our instruction, Your Lordship, there is no fire at all, Your Lordship. This is a simply made up.
Do the investigation.
Your Lordship. Therefore, they have done the investigation and they have submitted the charge sheet also, Your Lordship. Now the matter is up for trial, Your Lordship. Already 52 days behind the bars, and absolutely there was nothing with regards to any fire in any shop, Your Lordship. Therefore, we are praying that we may be allowed to take our best defense in the course of trial, Your Lordship. Kindly may be allowed to go on bail, Your Lordship. Already charge sheet has been filed. Moreover, Your Lordship, at the time of forwarding, Your Lordship, the police has claimed 3 grounds on which the custodial detention was necessary in page number 16, Your Lordship. Those have been fulfilled as of now, Your Lordship.
How many days you are there?
Your Lordship, 52 days behind the bar, Your Lordship. Your Lordship, kindly may come to page number 16, Your Lordship. Page number 16 of our petition, Your Lordship.
What is there?
Your Lordship, here when he was arrested, the necessity of his custodial detention, around 3 grounds were given. One is that custodial interrogation is necessary to ascertain the manner of commission of the offense, recovering any incriminating materials, and verifying the sequence of the events. All this has been fulfilled, Your Lordship. So we are humbly praying that further custodial detention may not be necessary at this stage, and he may be given an opportunity to defend his case, Your Lordship, at the trial stage. At the charge hearing stage, at least, Your Lordship.
If I may just place Lordship, the cognizance has been taken under 326G.
Indeed.
If Lordship kindly takes up that carries a punishment for life, Lordship. Arson. And here, Lordship, the eyewitness is also there. And Lordship, charges has not yet been framed, Lordship, as per the TCR. So at least, Lordship, the charges may be framed and at least the eyewitness should be examined, Lordship. Because they have a long history of quarrel between them, Lordship. And the offense is very serious, Lordship. Last date was 26/5 for copy. So in the meantime, if charges has been framed, Lordship, I'm not sure, Lordship.
So we are praying, Your Lordship.
I peruse the TCR, Lordship. I peruse the TCR, Lordship. Last date was 26/5/26 for copy.
We're humbly praying that we're ready to participate in the trial, Your Lordship. And at the charge stage also, we'd like to contend the charges also, Your Lordship. Let's kindly be the liberty to be participate in the trial, Your Lordship.
Heard, Mr.
TL Oscar, TL Oscar.
Yeah, last quarter, and it comes up with things, use the copy. distribution of the behavior before the street. This is an application to the section for the think of BNSS. Usually complete range for bail to the accused, to the accused that you can in connection with one copy is case number 63 registered under section 326 in the small g of the BNS 2023. Please. The FIR was lodged on 16/4/2026 by one Mukesh Karmapati. For the long of inspection, releasing that on 15/4/2026 at about 2 p.m. The accused applicant set fire a complainant's house. It was also alleged that the incident occurred due to long-standing quarrel between the complainant's sister's husband and the applicant. Allegedly having external affair involving the accused applicant's wife. The list that you put the act of person, a shop belonging to one Mr. Both of those has been completely destroyed. First, it was alleged that property damage amounting to approximately 4,000 cost of due process act on the accused receipt of the FIR. Police registered one of these cases, 326 in bracket, small g. Yes. After completion of the investigation, the charge by CS number 48 was laid before. Is pending where?
CGM Shankardev Nagar.
CGM
Shankardev Nagar Bajaj.
CGM Shankardev Nagar. The learned function that penetration is equipping submits that the accused applicant is behind the bars for last how many days? 52 days. 52 days. 52 days. 52 days. And 2 days. And nothing more. 52 days. And since charge sheet has already been filed and said is custody there's a case they are required. So this one on it poses the bill, submitting the bills, sufficient scope has done this year that has been received from the same case and has also heard considerations. Also, the paying for the school departments. Taking into account of the fact that the case of technical respect for 50 days. Behind the bars and charges will be framed in the same case. In the case of the considered opinion that the increase of the should be granted in this case. Accordingly, it is directed with the release of the very policy and very wonder of 60,000 and say nature to the CGM for the condition. Use of the so open the style, open the bank and make some sort of hasn't been required for the passport. It's in view of election this year to be submitted.
I'm deeply obliged to it. Deeply.
With pleasure, Lordship. Not here.
Petitioner, my lord, engaging in the jail hazard, my lord, since 17 to 25, my lord, till date about, my lord, 8 months. What happened, my lord? The case under section 103 BNS, my lord, page, FR in page 11, my lord.
What is the stage now?
My lord, already 4 witnesses were, my lord, examined. Evidence stage, my lord, evidence, my lord, informant, vital witness were, my lord, examined, my lord. I have annexed all the.
Lordship, may I point out one thing, Lordship? Here, Lordship, the accused is the son of the woman who has been killed. He stabbed his own mother, Lordship. Now, Lordship, here, if Lordship sees 4 witnesses have been examined so far, Lordship, and they are all family members. Now, Lordship, one witness is there whose 183 has also been recorded. I have flag mark. That is Meena Roy. She is also a witness of the incident, Lordship. She is an eyewitness and she has not been examined so far. So, Lordship, that third part is always there, Lordship, because they are all family members. So, Lordship, until that person is examined, Lordship may not consider this bail application.
What is the name of that person?
Meena Roy. I have, there is 183, 2 183 statements are there, Lordship. I have flag mark, Lordship, 183 statement. Meena Roy. Yes.
Meena Roy or Roman Roy?
Meena Roy, Lordship.
Monica
Roman Roy has already been examined. PW4.
Meena Roy.
Yes.
Difficult at this stage.
My lord, the only thing, my lord, there is no sufficient witness, though. Only thing is that there is a chance of conviction. There may be conviction, my lord. He may be. So what happened, my lord? He has 2 minor children. I have annexed the documents. And a wife, my lord. As the incident in between the own relatives, my lord. So wife and the minor children, my lord, financial hardships, my lord, nobody can. So, my lord, he may be convicted or not, my lord, that is separate thing, my lord. At least, my lord, I pray before your lordship, my lord, on humanitarian ground, my lord, only he may be allowed to a few months so that he can, my lord, sell some property or, my lord, arrange some money to, my lord, to manage the rest of the life of the my minor children and wife, my lord. That is my lord, and I have not taken any, my lord, ground for the merits of the case. He may be acquitted, he may be convicted, my lord. I have not taken any ground. Only one witness is, my lord, remain. I think if, my lord, he released, but he acquitted, that all right, my lord. And if he convicted, then it will be impossible to come out from the jail and to manage. Because, my lord, immediately after incident take place on 9, he was arrested on 10, my lord, immediately. So what when he is day wage laborer? At least, if he may be allowed, my lord, a few months, then he can arrange some money, my lord. Here, my lord, the punishment is life conviction, my lord.
Yes, Mr. Sharma.
Only that much.
Submission.
Lordship, here
Minor children, entire life will be doomed, my lord.
Lordship, this humanitarian ground, Lordship, is not tenable, Lordship, because in cases of murder and conspiracy, Lordship, the Supreme Court has also stated, Lordship, that bail is the rule, jail is the exception is will not be sufficient enough, Lordship. Lordship will kindly come to paragraph number 31. Just one paragraph I'm reading, Lordship. Paragraph 31. Yes, Lordship has found it.
Yes.
Yes, evidence on record before the session court till now has been noticed by us. Bail is the rule and jail is an exception. Although is a cardinal principle of bail jurisprudence in India, it is not an absolute rule. The rule is sort of a guiding principle that should be kept in mind along with the facts of each case and statutory restriction, if any, while considering a prayer for bail. In relation to offences such as the one under consideration, murder, and conspiracy as serious offences. 437(1) of the CRPC bar grants of bail if reasonable grounds exist that the accused has committed an offence which is punishable with either death or life imprisonment. The cardinal rule has to be balanced with factors like prima facie case, gravity of offence, nature of evidence, antecedents, differentiation of roles, parity, delay in conclusion of trial, age of the accused, medical grounds, etc. However, bail could be declined if the offence is heinous and premeditated. There is a grave apprehension of the witness has been influenced or the evidence been tempered, a possibility of the accused absconding, should he be granted bail and thereby even trial. Now, Lordship, here, Lordship will see the offence was committed in the presence of many people, Lordship. He attacked his own mother, Lordship, and mercilessly killed her, Lordship. And one witness is yet to be examined, Lordship.
That is the report matter. Already four that were examined.
Saying the learned counsel, paying for the accused applicant also have should be, we shall not allow the for the state. This is an application in the section for to the BMSS for paying for grant of bail to the accused applicant. To make applicant in connection with sessions case number 345/2 pending in the court of resources only. The learning council is going for the submits is in jail for last how many days?
My lord, 8 months, from 8 months to already 8 months complete, my lord.
For 8 months and 8 months for more than 8 months and trial is at the and the trial is at the evidence stays on. He submits that vital cases the extent is over the family members of the victim, and the accused, victim and the accused person itself are already examined. There is no requirement of, there is no trick, there is no trick of any trick of any influence, trick of influencing, any trick of influencing the witnesses in the instant case, and therefore he submits that taking it out is wrong. Then should instant case, it's not a case of people should take a long wait at this stage. The learned proposes the clear profile and has stated that the vital witnesses, some vital witnesses involved in the instant case are yet to be examined. Therefore, there are every possible chance that the may be influenced by them on those that depend on this police. They display next the PCN less than police. It is seen that one of the because the post report post case under we also see that we also see we compensation committed by use. I think they can give me a check from this conference as well as the fact that some public examine scope as finding a reason to grant a the accused suggesting of this case. In view of their person, the instant application is rejected. Easier to send off.
In this case, both the petitioners are behind bars since last 40 days. And what happened in this case, Lordship will find from the FIR itself, my lord. At page 17, my lord. Yes, in page 17, Lordship will find. May I read out the FIR, my lord? With reference to the subject cited, I have the honor to state that on 29/4/26 at about 9:10 p.m., information was received over phone from police control regarding an alleged acid attack at Lalganes area. Acting upon the said information, self along with police personnel immediately rushed to the PO and found one injured person, namely Orup Bosso. The injured was immediately shifted to Hayat Hospital for medical treatment and was later referred to Gauhati GMCH for further treatment. The accused persons were apprehended by local residents at this spot and subsequently taken into safe custody. During preliminary inquiry at this spot and statement of the injured, it was revealed that on the same day at about 8:40 p.m., a quarrel took place between the injured and below named his in-laws along with his wife Rita Das at a jewelry shop where the victim was employed. During the course of altercation, the below named accused persons allegedly assaulted the victim, as a result of which he fell into acid kept in a plastic container, thereby sustaining grievous burn injuries. Therefore, this case was registered. My lord, the accused persons' names, sir, those are before your lordship. Those who have been on the next day, they have been sent to judicial custody. My lord, from the last line of the FIR, it is very much clear that they were become the victim of circumstances. The entire incident occurred. It was a case of scuffle, or it may be assault, which is section 115, subsection 2 of BNS, and that is available, my lord. And in regard to section of 124(1) of BNS regarding acid attack, my lord. In this, it is speak 124 subsection 1 of BNS speaks that deals with the offense of voluntarily causing grievous hurt by use of acid, etc., which is a non-bailable offense. Except this 124(1), other sections, those are invoked against the petitioners are all are bailable, my lord. And with regard to there was no intention, my lord.
Yes, Mr. Swami.
Lordship, regarding the incident, Lordship, witnesses are there and the statement of the victim has also been taken. Indeed, Lordship, there was a scuffle. He was pushed and he fell down in a...
Some contained.
Yes, and Lordship, he suffered some injuries. But Lordship, the extent of acid injury, that is not in the case there, Lordship. The medical reports are not there.
But that is, I mean, that is not required. I
Yes,
think
Lordship, I leave it there.
because it's an accidental.
Yes,
This is not-
all our family members, Lordship, mother-in-law and brother-in-law. And wife was also there.
No. Pardon, Mr.
Paul.
If all the learned counsel applying for the case applicant. Also heard to be served the learned A to be forest. Is an application on the section 483 of PNSS. Paying for grant of bail to the accused persons. In connection with dispute police case number 257/2026, instead of the section 126, stroke 115 bracket 2 stroke 124 bracket 1 stroke 3 5 of VMS. And FI was lodged on 34/2026. 34/2026.
Yes, my lord.
26 by 26. 26 by SI Sumit Mahato. Alleging that on 29/4/2026 or 9 an information was received by the police person regarding something released accident at Lalganes area. That on typical of that when the police arrived at the place, the police found one person injured, namely Orup Bosso, with previous burn injuries. He was taken to the GMC Medical Hospital for further treatment. That the accused persons were taken by residents spot. They were taken by police upon custody. That during preliminary inquiry at the spot was found that quarrel took place between the injured and and his name and his in-laws along with his wife. They were very soft. And during the scuffle, the injured person fell into some kept in plastic container whereby he sustained burn injury. We learned it next on the basis of the FIR. On the basis of the FIR, this to case number 127 registered in the section 136 115 124 1 stroke 3 5 of BNC. Anyway, the limit so each that there was no text of incident where this person is the victim. It submits that there was some incident of there was an incident of altercation and thereafter scuffle between the parties. During such scuffle, the injured accident failed, but the AC kept in a plastic container. It submits that since there is no intentional injury in instant case, which is the section who relates to acid effect?
Section.
124. 124.
124.1. Yes. Page 6, madam.
That is the only non-billable one.
Non-billable.
Others are billable.
All are.
He submits that section 124 one of BNS will not be applicable in the instant case as there was no intentional acid involved in the instant case, as can be seen from the that has been lost and that has been lost. Full stop. He further submits that all other sections which has been where all other sections involved in the instant case are available offenses. We submit that they is fail at this case to stop. Submission Is there any other material? Nothing.
No, no.
Is there in the instant cases is produced of the materials in the apparatus as well as is there a disposal like these certificates should be granted to electricity different. The accused applicants, it is particularly directed to the accused applicants shall be released from that will be released on furnishing of bail bond of rupees 20,000 with security of like nature. Like nature subject to the satisfaction of
CGM Kamrup.
CGM Kamrup
Metro.
CGM Kamrup subject to the condition.
Kamrup Metro, madam.
Kamrup Metro subject to the condition of the accused defects shall cope with the investigation and shall not involve any activities of witness influencing any witness that may be involved in the instant case. In view of the course of damaging, the instant bail application is disposed.
May I please, your lordship? Lordship, this is a bail application filed under section 483 BNSS, my lord. My lord, it is a 60 days offense, my lord. The offense is primarily, my lord, criminal breach of trust and cheating, my lord. Registered under section 316 and 318 of BNSS, my lord. Lordship, may kindly see the FIR. FIR is page 11, my lord. Translated copy. And the original FIR is lost in Hindi, my lord. So FIR 11 is the translated copy, my lord. May I read it, my lord?
What?
May I read the FIR?
Yes, yes,
Is
yes.
my lord. My lord, the allegation is the complainant is from Nepal, my lord, the resident of Nepal, my lord. He came to Dhemaji for purchasing gold, my lord. As revealed in the FIR, my lord, he stated that my name is Tej Bahadur Sahi. I am from Nepal. One woman who is resident of Tezkuri, Dhemaji, Assam contacts me, whose original name is Rupali Singh. The Rupa Singh said to me that she have 2.2 gram, my lord, 2.2 gram gold, which I came to Dhemaji. At the time, there was one female and three male people in the house of Rupali Singh. She said that Arjun was her husband. That was on 8th March 2026, my lord, Sunday. There was 3 date has been mentioned in the FIR, my lord. And again, my lord, they again called me on date 19 April 26. At the time, there was 1 and 3 male people in her house. That day, they gave me few milligram of gold. They gave me few milligram of gold. And Rupa Singh came along with me to check the purity of gold to Dhemaji Bazaar, my lord. After Rupa Singh again called me on dated 2nd May 2026, my lord. Lastly, 2nd May. That was on Saturday, my lord. And gave me fake gold after receiving 3 lakhs. At that time, there was 1 female and 3 male person. I have given 3 lakhs to Rupa Singh. That is the petition in this case, my lord. After knowing all, I come to Dhemaji, Assam and went to Rupa Singh house. Rupa Singh said all the incident, my lord. So this is, and lastly, my lord, the relevant portion of the FIR. Lastly, my lord, he alleged that I request to the Assam police to help me to recover my money, my lord. In the FIR, the quantity of alleged fake gold is 2.200 gram, my lord. That should be 2.200 gram, my lord. And nothing has been recovered from the position of the petitioner, my lord. Lordship, kindly
2
see
gram,
the
it is 2 gram or 200 gram?
200 gram, my lord. 200 gram, my lord.
Huh?
In Hindi, original FIR, typographical error, my lord. 14, page 14 is the vernacular form of FIR, my lord. Hindi, my lord. 2.200.
That means 2 kg, 200 grams.
Yes.
Yes, sir. But in FIR, 2.2
Is
gram,
there
my lord.
anything, Mr.?
Yes, Lordship. Here, Lordship will see that the complainant is a resident of outside Lordship, and he was induced into coming here, stating that they have a boat, Lordship, golden boat, around 2 kg, which will be given to him at a very low price. And acting upon that misrepresentation, he came here and handed over 3 lakhs to the woman. And at that point of time, there were 3 other persons with her. Subsequently, he found that the gold is fake. And Lordship, now all the co-accused, they are absconding, Lordship. And the money has also not been recovered as of yet. And today is, Lordship, 26 days to my calculation. So, Lordship, further investigation is still going on, Lordship. Because he has been cheated of 3 lakhs. Gold is also fake, Lordship. And the source, Lordship, is yet to be ascertained, Lordship. And the other co-accused person, they have not yet been arrested. And who happens to, one of the co-accused happens to be his, her wife, husband.
Husband.
Yes.
Yes, Mr. Gogoi.
With all respect, my lord, but the alleged fake gold has been recovered from the position of the complainant, my lord. Lordship, may kindly see page 23, my lord.
Yes, but it was given to him. It will be recovered from him only. Otherwise, from
Yes.
where it will be recovered?
It is an allegation only, my lord, but in the FIR,
The thing is that like it's a fake thing.
my lord. But FIR's lordship, may kindly see the date on 2nd May.
No, I don't think we can grant bail at this stage.
My lord, our FIR's laws on 12th May, my lord.
Investigation is still going on. It will require some time. I think this is the record going on there.
Yes, Lordship.
There's a big record.
Exactly,
involving
And in and around these areas only, Lordship.
Antecedent, my lord. With all respect, my lord, against the petition, there is no any criminal antecedent, my lord. He has been wrongly arrested. He has been wrongly alleged in this case, my lord.
I heard Mr. S. Gogoi.
Yes,
S.
my lord.
Gogoi, the learned counsel, appearing for the accused applicant, also have Mr. B. Sharma, the learned APB for the state. This is an application of 483 of DNSS, praying for granting bail to the accused applicant in connection with Dhemaji PS case number 2026 under section 61 in bracket 2 stroke 3162 stroke 318 bracket 4 of DNSS. An FIR was cast on 15
12th May, my lord.
12 May 2026.
12 May 2026 and by one Tej Bahadur he the informant alleging that he came into touch with one woman, one that is used case and she promised him to give gold, gold, pure gold on paid, on paid, typical, then like accordingly, the accused applicant had handed over gold, gold and in gold, a piece of gold weighing weighing 2.200 grams. And for that, rupees 3 lakhs was paid by the informant, the accused person that after that later it was found that the gold that was cut with the with the with the informant was fake. So in view of the opposite, in view of the filing of the opposite FIR, Yamaji Police case number 82/2026 was registered under requirements section post. Learned counsel appearing for the accused of the case. There are in the offense, there are several contradictions against the case and against the case, and the accused applicant is linked to the offense as has been alleged in the report submits that since the goal has already been recovered and gold has already been recovered. What about the money? Money has been recovered. Gold has already been recovered. The accused applicant to granted bail. And since the accused applicant has already spent 26 days in the bus, she should be granted bail at this stage. Mr. B. Salva, the deputy rather opposes the bail application. Stating that the investigation is still going on. 4 accused persons are yet to be arrested. Yet these are yet to be arrested by the police. These are in the instant cases were produced. The same is produced to hearing the parties, after hearing the counsel, the paying for the parties. Parties taking into account of the fact that the money is equally recovered as well as other co-accused persons are yet to be dispensed by the investigating authority. This is not a big case moving accused of being should be granted this case. Accordingly, the instant bail application is rejected, dismissed.
Oblige, Your Lordship.
54 Lordship, charge sheet has been submitted.
You go there. But Mr. E. Kalundar, the Learned Senior Counsel is Mr. P. Choudhury, the Learned Counsel, very choice is to an applicant. Also heard Mr. Is in the situation in the section 43 of the system. As the failed vehicles of in connection with Bazar BS 6/56, registered is 27 in the 35, stroke 75, stroke 294, stroke 61, with the two of BAs. Register the fire. You get 152 the clause electronic is that is used stroke based scripting option for the branch or taken by force in front of the informant's parents' house. Then you know in the learned Mr. B. Sharma, PPP, submits the charge sheet in the instant case of already being filed by charge sheet number
58/26, dated 58, dated 24/5/26.
the city calendar and learned and submit also in view of the commission references means that it means that we should be allowed to approach the appropriate point. I believe in view of the this case is this is closed with the liberty to the accused applicant to approach the appropriate forum if so advised.
Trial court will consider in accordance with law.
And the learned jurisdiction report is bail application or in accordance with law.
Much.
27, Lordship, we have received the report that from Itasali OP, that no case has been lost.
No case is raised.
I am appearing on behalf of AK Sharma.
So there is no case, we are dismissing this.
No, better be pass over for the time being.
No time being there. Please take a case of.
Apurva Kumar Sharma.
Which of course,
Apurva Kumar Sharma.
which one? There are two appropriate.
Lordship, at least from the
But we cannot keep it. Or Mr. D. Medi, the learned counsel appearing
on behalf of AK Sharma.
appearing on behalf of Mr. A.K. Sharma, the learned counsel for the accused applicant. Also for Mr. B. Sharma, the learned PPP statement. The instant anticipatory bail application has been filed with the apprehension of being arrested by the filed by the accused applicant on apprehension of being arrested in connection with certain case which was in connection with certain case post. No details of any FIR or complaint would be provided by the accused applicant in the application filed by the accused applicant. Accordingly, this court has by this order 262026, a report was all from the concerned police station during the course of when the matter was taken up, okay, the report so called for has been submitted by the learned PPP by communication dated 2/6/2026, which is kept on record markings. The proceed report reveals that there's no case has been filed. Is in which police station is this?
Itasali, Lordship in Nagaon.
Itachali
Nagaon.
outpost.
Nagaon. It's from Nagaon. And Lordship, order dated 4/5/26, Lordship. It is stated by the prosecution also that GD entry was there, Lordship, and there was a interim that no coercive action may be taken as part of GD.
GD entry is there, but I mean, GD entry was there, but we the court has asked for this thing report. Necessarily directed to take it because whether any case is raised or not. There is no case raised. No case raised. This court by this order dated only 4/5/20 cases are not 26/20. 4/5. Last time it was registered against the accused in Itachali That right there, huh? Please.
Lordship, regarding the interim lordship, regarding the ZD lordship, no corrective action may be taken in regards of that ZD lordship. That will be considered.
It cannot be.
How that will be possible? That means like you'll be given the all these things of full relief
Only
without having any this thing. Cannot be given like that. So maybe how it can be given?
interim was already there,
But
lordship.
right, the interim was given only because to find out whether any case was found.
Yes, but
Registered.
there is no case.
If the case is not registered.
The ZD entry still remains.
That is that video entry still remains. I mean, if there is a case, then you come to the court. You come to the court. In view of the opposite, in view of the opposite, in view of the opposite fact that there is no case registered against the accused applicant, we can export the evidence that there is no apprehension of arrest against the applicant against sentence. Accordingly, the interim relief so granted on 4/5/2026 is hereby repeated, and the instant petition is dismissed.
Denial Lordship, petitioner is an interim. He has appeared before the IO recorded his statement. Lordship kindly goes to the FIR. Custody interrogation may not be necessary. He is the branch manager. Vehicle was purchased by the complainant Lordship. Subsequently, he could not pay the EMIs. So the vehicle was taken back and it was sold off in auction and purchased by some other person.
Okay.
Now, Lordship, he has brought the allegation against the every official Lordship that the vehicle is still in his name and all these allegations. So he is only the branch manager. It is the yes, Lordship.
Heard Mr. R. D. Collated also appearing to take this opinion, also heard Mr. B. Sharma, the representative of the state. This is an application under the report praying for grant of PRS 20 accused for applicant. Next will be targeted PS case of 2026 and corresponding to PR number 2026 registered under section 61 stroke 318 stroke 316 stroke 316 packet 5 BNS 2 this court by its order dated 15/5/2026 has granted interim pre-arrest bail to the accused applicant full stop, with the direction that the accused applicant should accused applicant shall appear before the investigating authority within a period of 7 days and fully cooperate with the investigation. Full stop. The learned Mr. R. D. the learned counsel paying for the accused applicant submits that in terms of the order dated 15/5/2026, the accused applicant has already appeared before the IO and his statements have already been recorded. Therefore, he submits that at this stage his bail application should be made absolute. Mr. B. Sharma, the learned APP has also confirmed that the accused applicant has already appeared before the investigating officer. Taking into account the aforesaid facts, this court is the opinion that the interim relief so granted by this court by order at the 15/5/2026 should be made absolute in same terms and conditions as mentioned in the order dated 15/5/2026. In view of the aforesaid direction, the instant AD application is disposed of.
For Lordship, we have received the CD and petitioner is an interim. Lordship, his statement, he has appeared, Lordship, but his statement I have not found in the CD. So let it be after 1 or 2 weeks, Lordship, I will get it updated, Lordship.
Okay, heard Mr. M.I. Hussain, the learned counsel appearing for the accused applicant, Mr. B. Sharma, the learned deputy for the state, Mr. B. Sharma admits that the case diary, no case diary has been received, it is not updated when his party pays for some in view of the aforesaid, the matter will be listed on
From Golaghat, Lordship.
16th will do.
Lordship, 19.
19th.
Lordship.
19th.
I leave it to you, Lordship.
19th of any is this.
18.
Let it be on 19th only.
Lordship.
Let the matter be listed on 19th. Interim orders of past values and continue till the next date of list. All right.
CD received, Lordship.
Wait, please, your Lordship. It is an anticipatory bail application, Lordship. Then your Lordship will find the affair is at page 7, Lordship. Their basic allegation is against the petitioner is that the daughter of the informant has committed suicide on being mentally tortured by the petitioner over phone, Lordship. The Lordship will find the affair is at page 7.
Yes.
Yes, neither the petitioner ever lived with the deceased Lordship, nor any direct control with the deceased Lordship. Neither he lived with the deceased Lordship
42.
and has any direct control with the deceased. And it is the contention with the affair Lordship that he has been chasing the daughter of the informant for last 2 years. Therefore, thereafter there was a break, Lordship, and he came, Lordship, and made a phone call, and the daughter of the informant committed suicide by hanging in the civil pen. That means, as your Lordship know, the abatement requires a direct act on the part of the accused, Lordship, which left the victim no other alternative but to end his and her life, Lordship. Here in this case, Lordship, there is also a allegation of Lordship, love affair, Lordship, and thereafter there was a break, Lordship. So, if the allegation made in the affair, assuming it's true, it goes in my favor, Lordship, because there was
In your favor.
because there was no instigation or addition. If he really wanted to
Instigation, what kind of instigation is required?
if he really wanted to love her, Lordship, he would not have let her die, Lordship. And
How, because you are saying that she is not under your control. And how you would have stopped her?
that is why the allegation, I'm assuming that.
No,
Lordship,
you are
allegation
saying
are
that
not
like, she
true.
is not under your control.
Lordship.
Then how you could have stopped her from committing suicide?
He has no direct control because the informant himself.
That's why I'm asking how you could have controlled her from committing suicide.
She could have, Lordship, blocked his number, Lordship, or made a complaint before the police, Lordship.
Not Mr. What is your name?
B. Haldar, Lordship. B. Haldar, Lordship.
Not Mr. B. Haldar.
Yes, sir.
The learned counsel appearing for the accused applicant also heard Mr. B. Sharma, the deputy for the state. This is an application under section 482 of the BNSS 2023, praying for pre-arrest bail to the accused applicant in connection with a London PS case number 28/2026 under section 108 of the BNS. The file was lodged on 24 on 24/2026 by the informant, alleging that his daughter was mentally tortured. His daughter, aged about 16 years, was mentally tortured by the accused applicant for the last 2 years with proposals of love. That a year due to such harassment, his daughter had to absent herself from taking examination 1 year ago. That the accused applicant went outside this for some time. That again he came back and started harassing his daughter again. Due to such harassment, the minor daughter of the accused, the minor daughter of the informant had committed suicide by hanging herself. The learned counsel appearing to the accused applicant surmised that in fact the accused informant's daughter and the accused
applicant was in a love relationship and he has not done anything which could have lead to the commission of PROCEED by the victim. Which he submits that there is no incidence of any abatement from his side, and therefore, how many days were the no, and therefore he should be therefore the accused of should be granted 3 days bail at this case because case that in the instant case has been produced before this court and the same is very on perusal of the case diary. This court is of the considered opinion that there are prima facie sufficient incriminating material against the accused applicant of his involvement in the offense so narrated in the FIR and in the FIR. According to the instead of the
I just want to place one judgment of the Supreme Court. Kindly consider that. I just want to place one.
on what?
Regarding the abatement lordship.
I'm saying that I'm saying that there are sufficient materials against you. That's why I'm rejecting you.
The mere harassment lordship.
No, I'm rejecting it. You go to the higher court if you want.
I'm not saying that lordship. Yes. Is it tender as a boy of 20 years?
I understand. Huh?
Tender as a boy of 20 years.
Whose boy age is 20 years? Accused person.
Yeah. And because of and the Honorable Supreme Court also has that mere harassment is not constitute a abatement lordship. There must be some.
No, this court doesn't know anything about all this. We are just sitting here for just having cup of tea. Right?
Highly of it.
Also, my report was called for. We have received the report, Lordship. No FIR.
No FIR, we'll have to dismiss. Heard Mr. A. M. Ali, the learned counsel, if any further accused applicant, also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of BNSS 2023, paying for grant of 3 years bail to the accused applicant from apprehending arrest in connection with an FIR extra laws against the accused applicant by one local state. This court, right? Since there was no details of any FIR or complaint that has been produced before this court while filing the incident review application. This court by in order dated 26/2026 sought for a report from the officer in charge, North Gauhati Police Station, regarding any case regarding any FIR that has been filed against the accused applicant. Next, when the matter was taken up today, the learned APP they submitted a document in terms of the episode of the dated 26/2026 of this court, which is kept on record by Martin X. The episode report dated 8/6/2026 reveals that no FIR has been filed against the accused applicant against the accused applicant. In view of the opposite, this court is of the considered opinion that there is no apprehension of any arrest of the accused applicant in the instant case, and therefore the instant review application being put out is dismissed.
Lordship, I'm sorry, Lordship, this report, Lordship, may keep the first page, the other pages are, Lordship, the GD entry and all. If Lordship permits me, I want to take it back, Lordship.
Take it back, we don't want it.
Yes, only the first.
We're just keeping this
first page, yes, Lordship, yes. I'm aware.
All right.
CD received, Lordship.
Wait, please, your Lordship. Lordship, before I place the FIR which is now got registered, I'd like to place the order passed by this honorable court on the earlier occasion when petitioner approached before this honorable court before registration of the FIR on the same subject matter. I'm placing that page 16, Lordship, and the operative part at page 16. Page 16, Lordship, the order of this honorable court. Page 16, and the operative part at page would be 17, Lordship. I'm relying.
There is nothing.
Page 16.
16, yes.
Order of this honorable court.
Yes, in view of this later detailed report, call for from the Sansad outpost. In receipt of the report, the concerned person is here diagnostic. Yes, then.
And I would like to place maybe some. I would like to place Annexure 2, Lordship. Annexure 2. Annexure 2.
Page 18.
Page 18, no? Page 18. Annexure 2.
Yes.
Yes. Second paragraph, Lordship. It is submitted by Ms. Thushom, learned counsel for the petitioner, that present petitioner had a good relationship with one Silpa Sora, and after the death of her husband, he financially helped.
No, 1 second.
Say,
from where are you reading? Page?
Page 18, Annexure 2.
Annexure 2 is Annexure 2, which paragraph?
Second paragraph, Lordship.
Second paragraph is not, I mean, but you are reading. It is submitted that Mr. Sharma, that WT message has already been received.
Yes.
Not that 25-2 order, Lordship, 25-2 2026.
She is referring to
25-3 is there.
25-2 2026.
page
AB
15.
number.
Page 15. No, order dated 25.
Page 15.
Then it would be page 16. Continue to page 16, Lordship.
Yes.
Lordship. The Lordship got that this paragraph, second paragraph.
No, the record was called for, yes. Then
No, Lordship. I'm placing the fact that that is my case. It is so Silpa Sora, after death of her husband, he financially helped said Silpa Sora, accused petitioner, and the money was also returned by her with a check amounting to rupees 10 lakhs of HDFC Bank, and the check amount was withdrawn by the petitioner after following proper banking procedure on 18/4/2025, and thereafter about 1 year, she lodged a complaint before the police, for which the police from the Sankarnagar outpost is now harassing the petitioner, but till date the petitioner does not have any information as to whether any case has been registered against the present petitioner. The learned counsel for the petitioner further submitted the matter was purely a civil dispute, wherein monetary transaction alleged by the complainant. Accordingly, she submitted till receipt of the report. The petitioner may be protected in some interim protection. So and so. Then, in view of this, let the report be called from the outpost. Till that received, then hereby directed not to take any corrective death. So he was on interim and he was cooperating with the police. Now, Lordship, I am placing the vital part, that is page 20. 20. The from bottom, the transaction dated 18/4/2000 from the Silpa Sora. The check has been on against that. The check has been remitted.
Where?
Page 20, Annexure 3.
Yeah, I got
bottom 18/4/2025. We are in 26, Lordship. We are in 26. So 18/4. So 10 lakhs has been deposited. What was that, Lordship? When the petition, this Silpa Sora was in trouble.
No. This transaction is for what?
This transaction, Lordship, this petitioner helped her in various ways during her husband's death also, and for returning tapes. This is the answer. There was no formal agreement between her.
This is something FD.
No, this is not FD, Lordship. This is. I'm coming to that, but this is this money has been paid to petitioner against the help he has been against the borrowed money which she has taken for. So accordingly, she returned, and no dispute till receipt of this complaint. So in earlier occasion,
when this complaint was filed, then he approached before this honorable court and petitioner was protected. He cooperated with that. Thereafter, coming to know that case has been closed, then the instant case has been lost, lordship, on the same subject matter, lordship. Now, lordship.
The closure.
Lordship, I'm placing that.
Where is the closure? There was this FR was filed against her.
No, not FR, lordship. No, not FR. First,
the close means what?
Case was closed. Case one means AB was closed. AB, this anticipatory bail application was closed, finding that no case has been registered.
Yes.
So that was earlier he was protected. He was given the protection of interim bail. No coercive. Accordingly, he cooperated. Until now, he is cooperating, lordship. Now, lordship.
Interim order was vacated.
Thereafter, it was vacated since no case was found.
Oh, that's why it was vacated.
It was vacated and immediately.
No, what are you trying to make out from this?
Trying to make out, lordship, the moment on the same complaint, same subject.
There was no FIR or there was no complaint. There was, and because of that, this order, I mean, the report was called for, and the report found that there was no complaint filed. So that's why this was vacated. Interim order.
Right, lordship. Right, lordship. On the same subject matter, when he was calling and not disclosing the case number, so he had to come before this honorable court, filing this application, and this honorable court, understanding he's given the privilege of interim protection. Thereafter, lordship, that on the same subject matter of the complainant's same subject matter, the case has been AB has been closed. That no case has been immediately after the closure of this bail application, lordship, the instant affair.
Is there any bar? Is there any bar in doing so?
I'm not saying there is a bar, lordship. He has come up with the same set of.
Because there was no complaint filed earlier.
Lordship, the transaction all happened in the year 2025. It was now she.
So explain me what is FD? FD through digitalize something. What is this?
What is where, lordship?
FD means what?
FD is here. This is the bank code. I do not know, lordship. This is from her check. So check. She has given a check, lordship, written the name of the petitioner and all, and that has been encased. And it is the duty of the bank also, lordship. Even it is 50,000 or 1 lakh, bank has to get confirmation from the owner that whether money will be. That is a mandatory procedure. I believe that, lordship. Because even in a transaction of 50,000 also, they get confirmation that whether to, in big, not in 1,000, 2,000, 5,000, but in.
No, what happened to this 5 lakh rupees?
What 5 lakhs?
These 5 lakh rupees that has been deposited.
No, that is, I'm only placing this 18-4 transaction. 18-4, that 10 lakh, Silpa Sora. That is the present informant. She has given a check to the petitioner. Accordingly, a year back, that has been remitted in the account of the petitioner. Dated 18/4/2000. This statement I'm placing, going to show that, lordship, this is a transaction of a year before. Now she has come up with this application, projecting a story that lordship would be pleased to find that at page 10, lordship. After 1 year of she was peacefully handed over the check. Check was remitted in the account of the petitioner. No whisper, no complaint. Only in the month month somewhere around when we filed this in the month of February, she has come up with this complaint, lordship, projecting that petitioner had no agreement. This petitioner only helped her. She borrowed from her without any writing. They have not executed any kind of agreement. They've helped her, and she has promised.
Let us see the affair. Let us see that.
Lordship. Page 10, lordship.
18.4, there is another transaction.
No, same transaction,
No,
Lordship.
no, there are two transactions in.
There are two
18.4.
transactions.
One transaction.
I'm relying upon this silver
No,
soda.
no, what about this 5 lakh amount?
5 lakh,
18.4. And there is Bonamali Nath's name coming up there.
that is a different Lordship. That is from different.
No, Bonamali Nath is the accused person, right?
Accused person, but that is a different transaction because he's the transporter.
Some explanation is to be there. I mean, he's not your relative.
No, he's having a transport business. He's
Yes,
having a
Mr.
transport
Sarma, what is
business.
that? You tell me what is there in the secret.
Lordship has produced the FIR.
Yes.
Now Lordship will find this informant. Her husband had died in a road accident.
Correct.
There was an insurance policy. This petitioner's Lordship, this petitioner and another person is their Lordship. They approached this informant and stated that we will do everything needful, documentation and all. Checks were taken, documents were taken from the informant. Then subsequently, Lordship, she did not receive any information. One day, Lordship, she received a telephone call from the insurance company stating that, have you received our insurance money? 15 lakhs. It has been disbursed by the, yes. She did not know it, Lordship. Thereafter, when she verified, she found, Lordship, that her around 12 lakhs from the 15 lakhs have already been misappropriated. And Lordship, these banking details, the IO has verified, Lordship, around 2 lakhs rupees was transferred by cash by this petitioner. And subsequently on the same date, Lordship, money, 10 lakhs rupees was transferred via account, Lordship, by depositing the check or something like that, Lordship. So altogether, Lordship, this petitioner has misappropriated 12 lakhs already. And another co-accused, he has misappropriated 2 lakhs 95,000. Cash withdrawal was done by another co-accused. So now, Lordship, she has been duped of all the 15 lakhs that she was supposed to receive for her husband's death. And Lordship, this entire planning was done, Lordship, way before in February, because Lordship will see that order where just now they have pointed out this order dated 25 to 26, when this anticipatory bail was filed based on an apprehension that some case has been registered. They did not supply any information. Subsequently, the report was submitted before your Lordship that no case has been filed. That is Lordship 25/3/26. Subsequently, this FIR has come. It was filed on 22/5/26. So Lordship, beforehand they were prepared for this, and therefore this bail application was filed. So Lordship, let this case be dismissed, Lordship. They are not entitled to any relief, Lordship. A poor woman has been received of 15 lakhs, Lordship.
Lordship, that is a allegation, Lordship. Now, it's been a year, Lordship. From the date of transaction from our own account, it is not that the money has been deposited from insurance account to petitioner's account directly, Lordship. It is the case the money has been transferred from the informant's account to petitioner. And that page 16 of my AB application is the detailed story of the case that has been observed by this honorable court. It is not that we have placed something. We have on the details.
Whatever you have written in the petition or written in the petition,
Yes,
that will be observed in the order.
Lordship.
This is not an independent saying we are doing.
I'm still.
I've heard MSP Som, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned for the state. This is an application under section 483 of BNS, 482 of BNS 2023, praying for granting pre-arrest bail to the accused applicant in connection with Lanka PS case number 106 stroke 2026 under section 318 bracket 4 stroke 316 bracket 2 stroke 351 bracket 2 stroke 61 bracket 2 of BNS 2023. an FIR was lodged on an FIR was lodged by the informant on 25/2026 alleging that the informant's husband died out of an accident and and she and the and her husband was in fact covered by a personal accident policy with the Universal Sompo General Insurance Company Private Limited. Also, it was alleged it is alleged that uh, so the accused person along with along with his co-accused another person got to know about the date of the husband of the accused, husband of the informant, as well as the of the fact that that he is covered by insurance, approach the informant to help her out getting the insurance money. Full stop. It was alleged that in the opposite terms, certain documents as well as some certain checks have been signed by the informant and given and handed over to the accused applicant for doing the needful. Full stop. It was alleged that on 11/4/2025, the informant received a communication from the Universal Sompo Insurance Company Private Limited that they have deposited rupees 15 lakh into her account at HDFC Huzai branch. Then semicolon that however however by taking the recourse of deceit, fraud, and cheating, and with the intention in misappropriate the amount, the accused applicant had in fact withdrawn the amount, two amounts, that is one 2 lakhs and another 15 lakh, another 2 lakhs from the account of the informant to to the accused applicant's own personal. So, in view of the aforesaid FIR, the police registered the Lanka PS case number 106/2026 under the aforementioned section. Full stop. MSP Som, the learned counsel appearing for the accused applicant, submits that the accused applicant is no way linked with the incidents of stroke offense that has been alleged in the FIR. She submits that in fact the accused applicant used to help the husband as well as the informant on many occasions, and there is no event of any deceitful or misappropriation of money, deceit or misappropriation of money by the accused applicant. Therefore, she submits that this is a fit case wherein the accused applicant should be granted the privilege of pre-arrest bail. Mr. B. Sharma, the learned APP, on the other hand, submits that there are sufficient incriminating materials against the accused applicant in the case diary, and therefore opposes the prayer of bail by the accused applicant. Also, this court has gone through. The case diary is produced before this court, and the same is produced by this court. But Mr. Sir, how can these people can be so stupid? From the account with the name and all, how can they transfer money like that?
That has been given from the bank, information has been taken.
Lordship, may I intervene, Lordship?
No, nothing. Then what happened then? Now the same is produced after having found sufficient prima facie materials against the accused applicant of his involvement in the instant case, the involvement in the instant case as narrated in the FIR. This court is not inclined to grant any relief to the accused applicant at this stage. In terms of the aforesaid direction, the instant AB application is dismissed.
I'm obliged.
Here in this matter, my lord, we have not received the paper book, my lord. Here in this matter, we have not received the paper book. The paper book has been ready, my lord, but we have not received.
Paper book is there.
On 4/6, Lordship, Learned PP has received the paper book.
Okay, Mr. D. Bora, the learned counsel appearing for the appellant. Submits that he is yet to receive the paper book. Full stop. Mr. PP, we will provide a paper book to him.
We have one paper book with us.
All copies are made, my lord. We'll,
Okay, registry to
yes,
registry to provide a paper book in the instant case to the learned counsel appearing for the appellant. Full stop. Let the matter be listed after 2 weeks.
obliged, my lord.
May I please, your lordship. Lordship, may kindly check the office note.
So address is not correct, it seems.
Yes, lordship.
Hmm?
Lordship, we may be allowed to take steps by paper publication.
Paper publication. You find out the address, proper address.
Lordship, this is the address as per the FIR.
Hmm? You go. Give some efforts. All right, heard Mr.
NJ Demari on behalf of AK's office.
Office note 15/5/2026 reveals that. No, office note 46/2026 reveals that. That notice issued to respondent number 2 has been received answered with postal remarks, no such address from RTS. Petition of in view of the opposite, let the petition take fresh steps on respondent number 2. The steps to be taken within 3 days of 3 days from today. Let the matter be listed after 2 weeks.
Much of this.
You find out the address and then.
Lordship, we have tried to find him, Lordship. Even we have taken steps to the Elaka magistrate as well, Lordship. As per the office note, Lordship. It is in record as well.
Next day we will see.
Obliged.
Connected for the petitioner when the matter was called for, let the matter be listed after 3 weeks.
May I please, Lordship? Appeal against the conviction, my lord. In this case, record was called for and record was come, my lord. And IA is for bail, my lord. He is in jail since 115 days, my lord. Conviction is, my lord, 5 years, my lord.
Record says the reports in the PCR in the instant case has been received. Let the matter be listed after 2 weeks. After 2 weeks.
My lord, miss case, my lord. My IA, my lord.
No, I also
Date may be fixed, my lord.
after 2 weeks.
Right.
We are not have any hearing today. Huh?
Lords.
We'll have to sign, I'll have to pass certain orders, no time, not feeling very well also.
Yes.
So we'll, when do you want?
After
Immediately
vacation.
after vacation, then.
Immediately after the
Yes.
Lords.
Heard Mr.
Specify one
A
date
Dekha.
because,
A. Dekha, the learned counsel appearing for the petitioner, also heard Mr. B. Das, B.K. Das, the learned counsel appearing for respondent number 2, as well as Mr. D.P. Goswami, the learned APT for the state. Let them be listed after the ensuing summer vacation.
on the 16th, my lord, because old matter, my lord, long pending matter. 16th of July, my lord. Or 23rd, my lord.
23rd of
23rd.
Obliged.
Obliged.
Right.